Here.
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 Thank you. I'd ask Commissioner Carson to please lead us in the pledge.
I pledge allegiance to the flag
The United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Ladies and gentlemen, as well as commissioners, we always appreciate the use of these fine facilities provided by the First District Court of Appeal, but we would ask that everyone just bring water into the courtroom, nothing else. Please also remember to silence those cell phones. And it's a reminder that pursuant to Section 286.0114 of Florida statutes, the public has the right to comment on items that may be something other than a quasi-judicial proceeding that's occurring today. We invite you to speak. If you'd like to, we would ask that you please give it to Ms. Fulford, who is usually in the back chair, but today she chose the front chair. Thanks. Commissioners, I'd ask for a motion to approve the minutes from the October meeting.
motion.
So moved by Mr. Berger, seconded. Second by Commissioner Rosanka. Any discussion? All those in favor, please indicate by saying aye.
Aye.
Any opposed? Thank you. We'll move right on into item 4, and this is the matter involving Anthony Valley, number 16-063 and 16-066. Are there parties or counsel present today? And if so, would you please identify yourselves?
Melody Hadley, Commission Advocate.
Mark Heron on behalf of Anthony Valley.
We have before us a proposed stipulation between the commission advocate and the respondent, and as you know, the commission may vote to accept or reject the stipulation. This is not a pre-probable cause stipulation. So if the stipulation is rejected, the matter will be heard at the Division of Administrative Hearings, or the parties can attempt to arrive at a new stipulation. The complainants have the right to comment in writing on proposed stipulations, and we've received comment from both of the complainants, and that's what was just handed out. Ms. Hadley, I'd ask if you would present the stipulation.
Yes. Respondent served as a member of the Walton County Zoning Board of Adjustments. This is a case where respondent violated Section 112.3137 Florida statutes by having a conflict in contractual relationship. In the stipulation, a respondent admits that he violated the ethics law and agrees to the entry of a final order recommending a civil penalty of $1,000. I respectfully ask for the Commission's approval of the joint stipulation, and as you can see, that both complainants appear to be happy with the stipulation.
Thank you. Are there any questions for the advocate? Hearing none, Mr. Heron, do you have any comment?
On behalf of Mr. Valley, we'd ask that the commission concur and adopt the joint stipulation.
Thank you, Mr. Heron. Would entertain a motion?
So moved.
So moved to approve the recommended stipulation. Is there a second?
Second.
Any discussion? All those in favor of the motion indicate by saying aye.
Aye.
Any opposed? Thank you. The stipulation's approved. The next one involves Douglas Arlington Holder, matter number 16-068. Will the parties identify themselves for the record?
Melody Hadley, Commission Advocate.
Thank you.
Bucky Mitchell on behalf of Mr. Holder.
Thank you, Mr. Mitchell. Once again, I won't repeat it, but generally this is not a pre-probable cause stipulation. So again, you have the opportunity to reject it, and it will be heard at the Division of Administrative Hearings, or we can arrive at a new stipulation. Ms. Hadley, would you present the stipulation?
Respondent served as a member of the Florida House of Representatives. Regarding allegations 1 through 5, respondent admits to filing inaccurate CE Form 6s from years 2010 through 2014 in violation of Article 2, Section 8, Florida Constitution, and Section 112.3144 Florida statutes. In addition, respondent admits to a late filing for the allegation 5. Regarding allegation 6, respondent acknowledged a $20,000 loan, which is the basis for the allegation 6, as a liability which is reflected in his 2010 through 2014 CE Form 6Xs. Thus, the loan has been disclosed to the public. We respectfully ask for the entry of a final order dismissing Allegation 6 and recommending a civil penalty of $6,500 for the remainder of the violations, and to refer the matter to the Speaker of the Florida House of Representatives for action consistent with Section 112.324.8E Florida statutes.
Thank you, Ms. Hadley. Mr. Mitchell, do you have any comments?
Nothing else to add other than we would like you to adopt the advocate's recommendation on behalf of Mr. Holder.
Hearing that, is there a motion?
So moved.
Madam Chair, if I could, before,
Yes, Mr. Carson.
I believe when this was before the executive session, the commission, I abstained. Representative Holder was a member of the Florida House of Representatives when I was general counsel to the Florida House of Representatives. So I'd like to abstain from this vote as well.
Thank you. Any concerns about that, Mr. Anderson?
Thank you, Chair Anchors. I believe, if I'm remembering it right, Commissioner Carson, that we considered that to be an abstention last time where you did not have to file the form because he's not a current client. I believe it was a past thing, so I'm glad you announced it, and I'm comfortable with you not participating, and I'll talk further with you later about whether we need to file a form or not. I think probably not, but we'll refine that a little bit later. But so your position is you're just not going to participate at all in this matter, is that right?
That's correct.
Thank you.
Thank you.
Thank you. Yes. Commissioner Norris, would you restate your motion?
Move to approve the advocate's recommendation.
Second.
It's been moved and seconded to approve the joint stipulation. Is there any discussion? All those in favor, please indicate by saying aye.
Aye.
Any opposed? The motion passes. We'll move now to item number 16197 involving Debbie Muscarsell, I apologize, Powell. Will the parties or their counsel please identify themselves for the record and pronounce the respondent's name properly for me?
Melody Hadley, Commission Advocate. I can't give you your name.
No one else is here on behalf of the respondent. Thank you. Ms. Hadley, would you please present this? As again, this is a pre-probable cause stipulation. If the stipulation is rejected, commissioners will go straight into a probable cause determination. Ms. Hadley.
Respondent acknowledged that she failed to accurately file a 2015 CE Form 6 in violation of Article 2, Section 8 Florida Constitution and Section 112.3144 Florida statutes. She failed to list a property held within 2 retirement accounts. On October 26, 2017, respondent filed an amended form with the State of Florida Division of Elections. We asked the Commission to accept the respondent's stipulation that she violated the aforementioned statutes or Constitution and recommend a total civil penalty of $500.
Thank you, Ms. Hadley. Are there any questions for the advocate? Hearing none, is there a motion on this matter? Commissioner Berger moves to approve the stipulation. Is there a second?
Yeah, I'll second the motion.
It's been seconded. Any discussion? All those in favor of the motion, please indicate by saying aye.
Aye.
Any opposed? The motion passes. Thank you, Ms. Hadley. We'll move now to consideration of final action on cost and fees, beginning with the matter involving Nate McLaughlin, number 14-230. I'm going to read from my notes somewhat to make sure that we cover the procedural issues in this part of the proceeding. This is an attorney's fee proceeding that has been heard by the Division of Administrative Hearings. We have before us a recommended order from the administrative law judge recommending that we award fees against the complainant, Mark Richter. Will the parties or their counsel identify themselves?
Mark Heron on behalf of Nate McLaughlin, and with me here this morning is Tico Gimbel on behalf of Mr. McLaughlin as well.
Thank you, Mr. Heron. As no exceptions were filed, there appears to be no reason to hear argument by either the petitioner, Mr. McLaughlin, or the respondent, Mr. Richter. However, we still must proceed under the Administrative Procedure Act. This means that we are unable to reject or modify a finding of fact, and please listen closely to this part, unless we determine that there is no competent, substantial evidence to support the finding. And if we reject or modify, then a conclusion of law, we must find that our substituted conclusion of law is reasonable or more reasonable than the judge's. With that in mind, is there any discussion by the members or any motion?
Second.
Is there any Any discussion on the motion? Hearing none. All in favor of the motion to approve the recommended order, please indicate by saying aye.
Aye.
Any opposed? The motion passes and the order is adopted. The next one is regarding Frank J. Meeker, matter number 14-231. The preliminary comments are the same as in the last one, but just for the record, we will note that the recommended order from the administrative law judge recommends that we award fees against the complainant, Mark Richter. As you will recall from reading the materials, Mr. Meeker passed away during the course of this litigation and his wife has been substituted. Are there any parties present, their substitutes or their counsel?
Mark Heron and Tico Gimbel on behalf of Frank Meeker and his widow, Beverly.
Thank you, Mr. Herron. Because no exceptions were filed, there's probably no reason to hear any argument by either the petitioner, Ms. Meeker, or the respondent, Mr. Richter. However, once again, under the Administrative Procedures Act, we are unable to reject or modify the finding of fact unless we make the determination that I've previously described in the last matter. Are there any discussion? Is there any discussion by any member or a motion? Motion by Commissioner Berger and seconded by Commissioner Rosanka to approve the recommended order. Any discussion? All those in favor, please indicate by saying aye. Aye. Any opposed? The motion passes and the order is adopted. We'll move now to item 5 in C, involving Charles Erickson Jr., matter number 14-232. Once again, we have before us a recommended order from the administrative law judge recommending that we award fees against the complainant, Kimberly Weeks. Commissioners, please note that Ms. Weeks filed untimely written exceptions, but requested additional time in which to file further exceptions. No exceptions were filed by Mr. Erickson. We have copies of the exceptions that were filed, Mr. Erickson's responses thereto, the record that you've seen, and a draft recommended order by our staff that would deny Ms. Weeks' request for additional time, deny her exceptions, and adopt the ALJ, the Administrative Law Judge's recommended order. Again, at this time, would the parties or their counsel please identify themselves? Kimberly Weeks.
Mark Heron and Tico Gimbel on behalf of Charles Erickson.
Okay. Just again, for Ms. Weeks, you may sit down, but thank you for being with us. Under the Administrative Procedures Act, our review of the recommended order is like the review by an appeals court. We cannot take any new evidence and we are limited in our consideration of the order. The Commission may adopt the recommended order as its final order. The Commission may not reject or modify findings of fact unless it first determines from a review of the entire record and states with particularity in the order that the findings of fact were not based upon competent substantial evidence or that the proceedings on which the findings were based did not comply with the essential requirements of law. The Commission, again, may reject or modify the conclusions of law over which it has substantive jurisdiction and the interpretation of rules over which it has substantive jurisdiction, but it must state, and I ask you to listen to this part because this is our responsibility, to state with particularity its reasons for rejecting or modifying such conclusion of law or rule interpretation. Also, the Commission must make a finding that its substituted conclusion of law or rule interpretation is as reasonable or more reasonable than that which was rejected or modified. Rejection or modification of conclusions of law may not form the basis for rejection or modifications of findings of fact. Mrs. Weeks is present, but I note that her exceptions were not timely filed and we are not required to consider them. However, I do want to give the Commission the opportunity to discuss whether it wishes to hear argument from Ms. Weeks as to her exceptions.
I don't see where it works.
So you would suggest that we hear from her? I would. Okay. Ms. Weeks, if you would like to speak, which I presume that you do, you'll be given 15 minutes. And after that, Mr. Erickson or his counsel will have 15 minutes in response. Commission members, as you know, are free to ask questions at any time, and they also may ask questions of our staff. If you would like to, Ms. Weeks, please reserve time for rebuttal at the outset. let me know how much time that is, and we'll be happy to interrupt you as you get close to it so that you may save some time for rebuttal. As you come forward, Ms. Weeks, please note that this is not an evidentiary hearing, and we cannot take any new additional evidence or testimony.
Okay. First, I'd like to start off with the fact that when my exceptions were filed, they were filed on the 15th day. They were faxed on that 15th day, so I don't understand how they could be deemed as being not timely filed. I filed the first set of exceptions and asked for additional time because of Hurricane Irma not having power, water, and ability to and with mail and everything and having that delay. So it was the time was shortened, but I did get it faxed in before midnight on that 15th day. And that was the case with both Mr. Erickson and the case with Mr. Hadid. On Mr. Erickson's case, I was going to file additional, but then I got a call from the Ethics Commission telling me they would not be accepted. And I guess we don't even need to talk about the one with Mr. Hadid's case until we get to that, because I don't want to use my time up talking about that. But I'd also like to point out the fact that I believe my due process rights have been violated because I was not allowed to participate in the probable cause determination hearing. I was not able to address any incorrections that were in the investigative report. And the investigative report and the advocate's recommendation conflict with one another. And the information is conflicting, so it was not accurate. I believe you, as well as the administrative law judge, therefore has been misled. There's information in there that has been omitted. There's information in there that's not complete. And a lot of the investigation didn't have anything to do with the allegations that were set forth. It was information that wasn't even relevant. I also submitted evidence of exhibits with my complaint, and none of those exhibits were relied upon. And very few exhibits were, so I don't believe you were given the complete record, though that they were available. I don't feel like a fair, thorough investigation was conducted, and therefore you made a determination that the complaint was dismissed for lack of probable cause based on misinformation and lack of information. Also, for the DOAH hearing, I had asked we were offered the opportunity to state where we wanted the venue to be, and of course I selected a venue that was more reasonable and accessible to where the events actually occurred, and that was not honored. I also asked to appear telephonically. That was not honored. I had asked for a delay because I was going through some issues there that were preventing me to meet their calendar. That was not honored, but Mr. Herron asked for delays for the same time duration. Mine was deemed unreasonable, his were not. Because I wasn't permitted to participate, like I said, in the probable cause determination hearing and exercise my First Amendment right and my due process, I believe that this moved on to the DOAH prematurely. And I'd also like to mention the fact that Mr. Herron was, these complaints were handled by the county insurance company. And Mr. Herron contracted apparently with the insurance company to do that at a reduced rate of his regular rate of pay. It appears based on the petition for fees, what he is, I believe he's referring to is his standard rate of pay, which is above and beyond that. And for the amount of monies that are trying to be recovered in these petition for fees and costs seem to be the difference between his standard rate of pay and the rate of pay that the insurance company had paid him. The insurance company also defended complaints that, or allowed him to defend complaints that were personal in nature and not related to individuals' official duties. And also that the insurance company did not petition for fees and costs. The insurance company actually gave us documentation that they did not, will not, and would not be seeking recovery of fees and costs. It appears based on Board of County Commission meeting minutes that Mr. Herron solicited the Flagler County Board of County Commissioners to move these forward for fees and costs. And the commissioners have no expenses incurred. Mr. Herron has already been paid to defend those complaints. But if you look at the language in the petition, he speaks about the language of defending the complaints, and those were not complaints. It was a petition for fees and costs. So I think the fees that are being attempted to be sought are exorbitant, and they're not in line with what the expense would have been just for Mr. Herron's time of defending these, and if he accepted the $180 rate of pay for the insurance company to defend the rates, he should be accepting the $180 an hour to pursue recovery of the fees. He also said at the Board of County Commission meeting that no monies would be going to the commissioners. It would be going to the county. Well, the county had no out-of-pocket expenses. They did not pay for Mr. Herron to defend those complaints. So it's really not understood why Mr. Herron would even be involved in this, and a member of the public actually stood up and spoke at the Board of County Commission meeting asking if the fees were to be recovered, why would the insurance company not coming before the Board of County Commissioners to ask for that to be done? If fees are awarded, and you had commissioners that voted on this to move forward with this, and these commissioners didn't have any expenses, and the county didn't have any expenses, it would seem that somebody would be personally gaining that shouldn't be. Also, I'd like to mention at a prior, Mr. Herron tried this, and there's a DCA opinion there that identifies the fact that Mr. Herron attempted this before and gone back to search through public records. Mr. Herron hasn't been paid anything for fees by the county to defend this, to move this forward to the petition process, and it was not until September of 2017 that invoices were paid, and paid all the way back to 2014 after the administrative law judge made a recommendation to move forward and allow these fees to be granted. So to hold invoices for 3 years and find out that they're going to be granted and then start slamming the county with invoices that are 3 years old, and those invoices should have been paid in that fiscal year, or those funds set aside in that fiscal year to pay them when those invoices come in. So there's a lot of issues here that I don't think that the commission may be aware of, and you know, like I said, I don't want to waive any of my rights, and I'm really concerned that my due process and my First and 14th Amendment rights have been violated in this. And I have a document here from the Ethics Commission that states that only the respondent and the commission can speak at a probable cause determination hearing. Mr. Herron is involved in the investigation. Mr. Herron is only allowed to speak with the respondent in the probable cause determination hearing, and at no time does the claimant get to defend anything or say anything. And this is so unfair and unbalanced that, you know, I don't see this is how this process should be. And the purpose of the Ethics Commission is to hold people honest and accountable. And when it's one-sided and you're never able to be heard, and April of 2016, it came before the Ethics Commission to modify that and revert that to, again, it used to be that the petitioner was allowed to be heard at probable cause determination hearings. It came before the commission, and they took no action on it. So I've never in my life been to a hearing to where only one side gets to be heard and the other side, and the same thing was true with the hearing for petition and fees and cost. I was not notified of that hearing, but I received Ethics Commission communication that said that, Mr. Herron, are you going to be there, and noticed him of that hearing. So, you know, when I wasn't permitted to speak at the probable cause determination, I thought nothing of it, thinking, well, I guess I'm not allowed to speak here. Next thing I know, this is promoted onto the DOAH. So I believe that the DOAH was given bad information because the complaint was about things that were not material to the allegations. They were just, you know, I can't go into that because I don't have enough time. I mean, I could sit here for hours with you and talk to you about this stuff and tell you about that. But I believe that the ALJ, if she had to depend on the complaint and the advocate's report and the investigation report, and those were not accurate and complete and thorough, then she was not given good information to be made on my side to defend, and I wasn't permitted to participate telephonically. It was made in a jurisdiction that was unreasonable to think that I should come to Tallahassee and stay 3 or 4 days to defend this, and had issues that I was not able to be away from home for that long. So I just think that this whole thing here should not be granted based on that.
You have about 6 minutes left. If you'd like to reserve any of that time for rebuttal, let me know.
Okay. But I think it's worth looking into the language that Mr. Herron uses in the petition for fees and costs. And I think that he has misled the Board of County Commissioners when he presented himself there, making it believe that because he was working for the insurance company and defending those, that he was acting on their behalf. He didn't necessarily, I'm not saying he stated that, but acting on their behalf to recover fees and costs. But he's trying to recover far more than what the insurance company had paid to even defend these complaints. So I wasn't sure how this process worked, and I had a lot of information and things that I wanted to say, but the biggest thing is if monies were to be granted, that Mr. Herron would be the one that would personally gain, because he's already been paid to defend these complaints, and he's going to get additional monies from this action. It also, it has been known in the record that at a Board of County Commission meeting, when he attempted this in the past, that he was literally telling commissioners how they should vote and recommending for commissioners to file the 8B form. And the 8B form was filed in the abundance of caution. There wasn't even a reason stated on there. He's not the board's attorney, but yet he's inserting information like this for them to be able to make decisions on that. So I think that there's a big issue here that they need some serious looking at. I'd like to reserve the rest of my time for rebuttal.
Okay, you have 4 minutes. Thank you, Ms. Weeks.
Can I ask a question?
Yes, you may.
Ms. Weeks, so you made a statement that the advocate's report and the report for investigation were not accurately reflected of each other.
That's correct.
So can you tell me specifically, it's easy for me to say, what you mean by that?
Okay. Well, like I said, I got a lot of stuff here, and you're putting me on the spot asking me this one question. I could certainly give it to you in writing if I had more time, but I'll do the best that I can. One of the things is it asks Mr. Erickson, there were so many things here. Hold on just a second. It was that the fact that Mr. Hadid didn't say anything about the fact that he knew Mr. Erickson had financially contributed and attended a fundraising event. And it has been inaccurately stated in information that was given to the DOAH and to you that he only financially participated in this Mr. Meeker's reelection campaign, which was not true. Mr. Erickson also attended the fundraising event, but he kept that hidden. Okay, in one report of investigation, it only talks about the financial contribution. In the other one, in an investigative report, it talks about the fact that he did attend the fundraising event, and he did financially contribute. And he withheld that. Okay, so that was one of the things that are conflicting there that I can think of right now off the top of my head. So the whole picture wasn't given to you or to the DOAH. So that information was inaccurate, and decisions are being based on inaccurate information. Another thing is, it was said that at the Board of County Commission meeting that they only talked about the financial contribution, and they were saying that I was asking him to step down from the canvassing board because he wasn't accurate due to a financial contribution, which didn't make him an active participant. And that was not true. I did not tell him he needed to step down. I asked him to step down at that time because I only knew about the financial contribution because for the appearance of impropriety. I later learned about about attending the fundraising event. So in one of the reports, it states that he did both, and the other one is, and it doesn't. It only are the investigation and the report. So that was one of the cases, and this case is both for Mr. Hadid and Mr. Erickson. This information that I'm giving to you, it relates to both of these cases. But also the fact, in the investigative report, your investigator for the Ethics Commission denies the fact that Judge Stens and I relied on an opinion from the Division of Election that identified what an active participant was, and they allowed as an exhibit to be something that was produced a year after all of this took place. Had nothing to do with the complaint, had nothing to do with what happened at that time, and said, in fact, and this is the language used, in fact, it was Ms. Weeks and Judge Stens that violated the law.
Okay, Ms. Weeks, thank you. Any follow-up on that, Commissioner Cox?
No, not right this second.
Thank you. Any other questions at this time for Ms. Weeks? If not, Mr. Herron. Thank you, Ms. Weeks.
Thank you.
Mr. Heron, as you know, you'll have 15 minutes.
Thank you. Mark Heron on behalf of Charles Erickson. You've heard a presentation in terms of the procedures that were followed by this commission as well as by the administrative law judge with respect to the issues that were before the commission in this proceeding. The proceeding that you are asked to deal with is whether the allegations in Ms. Weeks' complaint against Charles Erickson were false or whether they were made with reckless disregard as to whether they were true or false. Ms. Weeks had the opportunity to participate in that hearing fully. Ms. Weeks was set for deposition, and she came to the deposition and said, "I'm not answering any questions on advice of counsel," and walked out. So she had the opportunity to participate fully in those hearings and present her case through deposition and in presence if she decided to come to the hearing, but she had the opportunity at deposition to present everything she's told you today and more to justify her complaints or attempt to justify the statements in her complaint, which we allege were false or made with reckless disregard of whether they're true or false. So to sit here and say that she was denied due process is not a fair and accurate statement. We all know the debates that this commission has had about complainants showing up at probable cause hearings, and I'm not going to go down that road too far. But that's a decision that you have to make as a commission as to whether you want that to occur. With respect to misstatements in the report of investigation, Ms. Weeks was interviewed by this commission's investigator and again had the opportunity to present her case to the investigator at that time. These allegations about the fees involved here, I think Ms. Weeks fails to understand that under the fee recovery statute that we're litigating under here, you are entitled to seek fees for collecting for the fees that have been previously paid in defending the amounts. That is what these additional fees over and above the defense are. It is clear in the petition that the monies collected, the $185 that our firm has been paid per hour, or the $180 our firm has been paid per hour, will go to reimburse the insurance company for the fees that they have paid out on behalf of Flagler County in this proceeding. There are additional fees in there to pay for the time of the county attorney and the personnel in the county's attorney's office who participated in the defense of these fees, or defense of this case. All these fees that have been paid or are awarded are consistent with the statute. We've asked for a reasonable hourly rate. The administrative law judge granted that. And again, based on evidence before the administrative law judge at the time. So we would ask you, and unless you have any questions, we would ask you to adopt the staff recommendation in terms of the draft order and award fees in this case. Thank you.
Thank you, Mr. Heron. Commissioner Cox, do you have a question?
I do. You made a statement just now about reasonable fees.
Mm-hmm.
So did you change your hourly rate?
No. Here is again, the evidence is in the record.
Yeah.
The evidence is in the record is that the county's insurance company indicated they would pay $180 for the defense of this matter. The county agreed to that, but they said that they would pay my normally hourly rate over and above that in the event we were successful.
So if you won the case, you get a bonus.
Not a bonus, but again, that's why we're asking for those fees here.
So what is the other rate?
The other rate my standard hourly rate is $300 an hour for Ethics Works because I'm a lobbyist and I can't, jiggle that fee based on stuff. The administrative law judge awarded $350 an hour based on the expert testimony.
How much is the county attorney's portion of this?
I don't remember specifically, but I would say that the county attorney portion in this, it probably ranges around $10,000 a case. This is just a rough estimate, $10,000 to $12,000, $14,000 a case, except in the case involving Mr. Hadid. because he did not represent the county or claim any fees with respect to his case. It's broken down in the I know in my proposed recommended order.
Any other questions of Mr. Heron?
Is it common for, not specifically about this case, but is it common for people to basically say it's inconvenient for me to come to these hearings and let me talk to you on the telephone? I mean, you do lots more of this than I do.
Well, first of all, these kinds of proceedings aren't common, okay, as you are aware. I can't say it's common or not common. I would say that in this case, the fact that Ms. Weeks walked out of the deposition, Ms. Weeks constantly had an excuse for not showing up. Ms. Weeks has represented in the course of the proceeding, and it's in the record, that she doesn't have an email address. Notwithstanding that, she keeps sending public records requests to this commission and to the administrative law judge on an email address that she gave the administrative law judge that she says she doesn't have, and we send things to her and she says she never gets them by that email address. So to answer your question, I don't think it's common, but the things that have happened in this whole series of cases is not common.
Any other questions for Mr. Heron? Thank you,
Thank
Mr.
you.
Heron. Ms. Weeks, you may have your rebuttal time, which I believe is 4 minutes.
I'll start at the bottom and go to the top. First of all, as far as the email address, the DOAH record but it was on record that I do not have internet access in my home. I live in a rural area of Flagler County where that's not available. It's not that I don't have an email address, I don't have access to email. When I can get to somebody's house that has that, or I'm in an area where there's, somewhere where I can get it, I try to. But right now I have 130,000 emails in my email account. So that was a mischaracterization of what was said. It was not said that I didn't have an email address. Also, there has been no excuses. If there was an excuse, I wouldn't be here today. I showed up for the deposition. The fact of the matter is Mr. Heron, again, tried to mislead you to make you think that I wasn't willing to cooperate because of the deposition. The fact is it never should have gone to the deposition. The advocate then could have relied on the information, and the information was incomplete and inaccurate that was given to her to rely on. Okay, so I went to the deposition, so that goes to show I do, and I'm here today, so that goes to show I don't avoid these if I know that I'm able to participate and be there. Also, Mr. Heron admitted to you it was additional $180, as Mr. Cox had said, was that a bonus? Okay, so he admitted that he's going to gain additional above and beyond what he was contracting with the insurance company to be paid to defend these complaints. So now he is looking to be paid a second time. Mr. Hadid represents the Board of County Commissioners. He cannot represent an individual commissioner in the insurance company paid for the defense of these complaints. So there would be no reason for Mr. Hadid to insert himself in defending a complaint that the insurance company hadn't contracted with him as they did with Mr. Heron to defend these complaints. So the cost for Mr. Hadid's, I think, are bogus charges in themselves based on that reason.
Ms. Weeks, I just suggest in the time we have, reserve that time for the Hadid matter.
Okay. And no, I was not interviewed by the investigator like Mr. Heron had claimed either. That's an inaccurate statement. So, but what's very important is Mr. Hadid did not ever admit to you that he is getting paid additional.
Thank you. Just before you leave, Commissioner Brady.
So Mr. Heron's characteristic of your behavior at the deposition is inaccurate?
That's correct. Mr. Heron is talking about an action that took place regarding the DOAH hearing, as he was preparing for the DOAH hearing. It had nothing to do with the ethics complaint filing before it got to the DOAH hearing.
But his contention that in asking to take a deposition, which is your right, you refuse to participate in the deposition on advice of counsel.
Yes, that's correct, because it was claimed that the recorded public meeting of the canvassing board where Mr. Hadid was heard in a whispered conversation to Mr. Erickson about voted absentee ballots being studied and cell phones being used to be reporting their study, and Mr. Hadid counseled him on it after that was captured on the audio, because it was believed that Mr. Hadid didn't expect that whispering conversation to be captured. That was when he claimed that it was attorney-client privilege information, which he cannot extend attorney-client privilege to Mr. Erickson. He represents the board as a whole, and that went through the judicial system and was determined that that was not illegal. And that was also part of my complaint that was never investigated, and the statute was relied on. When it's illegally intercepted, it can't be used in any type of a hearing. But there was no determination to confirm that it ever was illegally intercepted. But that was a criminal charge that I faced that has been dismissed, because no part of a public meeting is private, and there's no expectation of privacy at a public meeting. So at the time that was going on with the depositions, I believe, I could not speak at the deposition because I was still facing that, and I was advised by my attorney, not to participate. But like I said, that has been dissolved. That charge has been dismissed. So, but I participated in everything with the Ethics Commission before it got to the DOAH stage that I knew that I could participate in. So he's commingling the two events. I'm talking about before it got to that stage, because it never should have gotten to that stage had the information had been accurate and complete, and a thorough and fair investigation had been conducted, and I had been offered my First Amendment right to be able to participate in that.
Thank you.
Thank you, Ms. Weeks. Any other questions for Ms. Weeks? Thank you for your participation. And regardless of what happens, I want to at least share with you that we know you've been frustrated by the process that has limited the level of participation by the complainant before the Ethics Commission. And I did note that one of the statements from the administrative law judge in that order that might apply to that same concern was this: indeed, all citizens are entitled to criticize the government and to avail themselves of any legal remedies. And as I think you alluded to and have heard, we've had substantial discussions about that process. And although I think many of us acknowledge it's an imperfect process, like much of American government, it's the best that we've come up with so far. And we appreciate that you took the time and effort to make your comments and remarks today.
It just seemed interesting that was the practice that used to be.
Yeah.
And that Mr. Herron was a former chairman of the Ethics Commission. Mr. Herron spoke when that came before you in April and was again opposed to that. But his opposition to that actually benefits him in defending complaints and getting them dismissed for people, and it's a benefit to him all the way around.
All of which we have considered and debated, and probably will be debated on into the future. And those commissioners who are here, when that comes up again, I'm sure will be mindful of your position on that.
Thank you.
Thank you. Before we entertain a motion, I'd like to ask our general counsel if you could comment on the filing deadlines. Ms. Weeks referenced at the beginning of her comments that it's her position that she filed her exceptions timely, and my understanding that they were not. Could you clarify that for us on the timeline?
Yes, Chair Anchors, thank you. Ms. Weeks, I guess you could call them attempted exceptions. They did come in on that date, but they came in just prior to midnight on that date, 11:20-something p.m. is indicated on the fax transmission, and under the Commission's operating statement, which is viewable on our website and has been there for some time, it makes it clear that if you're going to electronically transmit a document to the Commission and it arrives after 5 p.m., it is considered filed on the following business day. And so under the posted procedures and operations of the Commission, as well as in conjunction with various administrative rules, and I looked at a lot of rules and statutes and things to determine that, in fact, her exceptions were untimely. Now, given that she did file something, I thought it best in preparing the draft final order for your consideration to treat the things that she offered as exceptions in detail. And that's why you do have an order before you that is somewhat lengthy. And assuming an argument that her exceptions were timely filed, which they were not, The draft final order still takes each one of them individually and explains why the exceptions are suggested to you by my draft to be rejected for reasons other than just the fact that they were untimely filed. Untimeliness is part of it. They were untimely, but additional reasons are given, and what she has offered to you as exceptions have been thoroughly discussed in the draft final order that I'm offering to you.
Understood. Thank you, Mr. Anderson. And thank you, Commissioner Cox, for asking Ms. Weeks to be heard, because even if the exceptions were not timely filed, I appreciate that we had a full expression of that. I'm sorry, Ms. Weeks, I can't call on you again. It's now just before the commission. And because of that, I would ask at this time for us to be able to have a full discussion that we have a motion presented by one of the commission members.
Move to approve the final order as drafted.
Second.
It's been moved and seconded by Commissioner Brady and Commissioner Norris to approve the recommended order. Is there any discussion? Commissioner Cox.
Yeah, thank you, Madam Chair. So, as I'm sitting here thinking about this, there's a few things that I'm disturbed by, and all of these cases are pretty, I guess, being a non-lawyer, I try not to use that too much because.
Too pejoratively, we get it.
Yeah,
To
yeah.
the rest of us.
I struggle with these types of things because it's just not in my wheelhouse, okay? But having the perspective of being a non-lawyer and a former elected official, I look at things maybe through a little bit different viewpoint. And as some of you will remember, I was very passionate about the fact that I think complainants should be heard at probable cause hearings. And this is the byproduct of why I was so passionate about that, because here we have a situation where an individual is faced with significant fees and costs that I don't know her situation, but it potentially could ruin her financially, and maybe the prior cases that we heard. So some of the things that she's hitting on is really hitting some buttons with me that, you know, when someone says, hey, I didn't get a chance to exercise my First Amendment right, that hits a lot of buttons with me, and it gives me big pause, and it reaffirms my belief that complainants should have a voice in the probable cause hearings, because this is the byproduct of them not. And so the conflict that she has raised between the advocate's recommendation and the report for investigation, I'm sitting here saying, would that have changed my mind in that original vote? And I can't tell you that it wouldn't have, had I known that and felt like it was a validated reason. The other item is the insurance company did not ask for this. The Board of County Commissioners did it. The people who had the complaint filed against them. And I really think that just stinks of politics. That it's like, well, we'll get even with you for daring to question our authority. And they're doing it using other people's money to get even from a political standpoint. And I just think that's wrong. And at a bare minimum, I don't believe that we should be granting fees at a higher rate. I think she brings up a very valid point. I mean, if you're willing to work for $180 an hour, that's what you ought to get paid. Just because he was successful does not, in my mind, believe that he should get a bump to $350 an hour. And I sure the heck don't believe that the county attorney, who's they're going to pay him regardless of what they're doing, should be reimbursed. The county should be reimbursed for the fees and costs that the county attorney has expended. I honestly don't believe that. So, you know, quite frankly, I think the other two cases, had there been a complainant here, we would have had this discussion a few cases ago, but Since there wasn't, I held my nose and voted in favor of it, but I'm certainly not going to support this motion in the form that it's in, and would love to see if there's other support for that.
Comments from any other commissioners or questions? Hearing none, the motion before us is to approve the recommended order. All those in favor of the motion, please indicate by saying aye. Aye. Any opposed?
Aye.
The motion passes and the recommended order is entered as a final order. Chris Anderson.
Thank you, Chair Ankers, and I understand that to be approval of the recommended order by way of approving the staff's draft final order. Is that correct?
Yes.
Thank you.
Adoption of the recommended order as our final order. The staff's recommended order.
Thank you.
Any other questions regarding that matter or clarification? If not, we'll be moving on to the matter involving Albert Hadid, number 14-233. This is item 5D in your agenda. A bit repetitive, but still for the record, you know that this is another attorney's fee proceeding that has been heard by the Division of Administrative Hearings. Again, we have a recommended order from the administrative law judge recommending that we award fees against Ms. Weeks. In this case, Ms. Weeks filed two sets of what she refers to as partial written exceptions, both of which were deemed untimely. She's also requested additional time in which to file further exceptions. No exceptions were filed by Mr. Hadid. We have copies, again, of the exceptions, the response thereto, the record, and a draft final order recommended by our staff that would deny Ms. Weeks' request for additional time, deny her exceptions, and adopt the administrative law judge's recommended order. I believe we have the same parties in council present, but just for the record, Ms. Weeks and Mr. Herron and Mr. Gimbel. Is that correct? Correct. Thank you. Once again, our review of this recommended order is like the review by an appeals court. We cannot take any new evidence, and we are limited in our consideration of the order. I will not restate the findings that have to be made. If you have any questions, please let me know, but they are the same as they were in the last case. We again have the opportunity to hear from Ms. Weeks, and I'm just going to go ahead without asking the commission if you have any new comments that you would like to make that are unique to the Hadid case. You're invited to come forward.
Thank you.
Would you like to reserve any time for rebuttal?
Yes, ma'am.
How much time? You have a
Can I
total
just reinstate, without repeating all of that I just stated, the same applies to this case. But I also want to mention the fact that it was said that my exceptions were filed untimely. The statute says 15 days. It doesn't say by 5 o'clock. So I still feel that my exceptions were filed on time because they were filed within a day period is a 24-hour duration. It says 15 days. It doesn't say by 5 o'clock. That I still say that my exceptions were filed on time. I also, on the recommended order by the advocate, I think he glazed over a lot of the issues that I raised, and I don't think that was a fair assessment of considering the exceptions that I raised, and also the fact that when I filed the complaint with Mr. Hadid, the main allegation was the fact of the whispered conversation of studying voted absentee ballots and counseling a commissioner that used their cell phone to report the study. That wasn't investigated. There was no reason to exclude it from being investigated, because it wasn't deemed that it was illegally intercepted. And if the complaint couldn't have been handled in its entirety, it should have been postponed either till the criminal issue was over or until that it could, or the complaint should have been, returned until it could have been filed. But because that was severed from the complaint, and it wasn't investigated, I think that's what helped defeat probable cause. And again, because of the misinformation, the lack of information, and the poor investigation that was done, and the records that were available weren't relied upon, actually relied upon the Board of County Commission Canvassing Board meeting minutes. When I historically prepared those meeting minutes for that office, since I took office for 6 years, and my predecessor prepared those meeting minutes prior to me. It was never a Board of County Commission employee that produced those meeting minutes, and why both of those records wouldn't have been relied upon, and only what was the Board of County Commissioners is unclear when I furnished all those exhibits with the complaint that I filed. But I also, rather than repeating myself for all the things that I've already said about the last case, the same thing applies to this one, because a lot of these allegations in here are the same. So, but I did want to make that point about the exceptions. It doesn't say in the statute that they have to be filed by 5 p.m. So I think that was unfair not to consider that, and I have problems with the draft order based on that, and it'd consolidate massive information into 3 sentences. So, thank you.
Thank you, Ms. Weeks. Mr. Herron?
Mark Herron and Tico Gimbel on behalf of Al Hadid in this matter. The issues again here are the same with respect to why we're here today. We're here today on a petition for costs and attorney's fees, and the issue in that proceeding is whether the allegations in the complaint, which were investigated by this commission, were false or were made with reckless disregard as to whether they were true or false. The same issues that we discussed previously are the same issues here. Ms. Weeks did have the opportunity fully to participate in that proceeding and present any defenses that she had, that the allegations she made in her complaint were true or were made with, I guess, reasonable efforts to determine whether they were true or false. She opted, like I mentioned before, not to participate in that administrative law DOAH proceeding. The only thing she did was show up at a deposition, and say she was not going to testify at that, and then walked out. Ms. Weeks continually references her First Amendment right to participate. I would point out to this commission the language in the Brown case, Brown versus Commission on Ethics. Person does not have a First Amendment right to participate in an ethics complaint proceeding where they have sworn under oath that these things are true and lie. You are not allowed to do that. And that's what the Brown case, when that defense was brought up in the context of a New York Times versus Sullivan type of argument. With respect to the service of the exceptions, you've heard language about this statute. There's also a model rule. And the model rule specifically says that they're supposed to be sent by email to the opposing party. And to this date, Ms. Weeks has never sent me a copy of her exceptions, late filed or timely filed, or however they were filed, in any way whatsoever. I have obtained them from the Commission on Ethics. I have downloaded them from the DOAH website, where she also filed them by fax in an untimely way. So your staff, again, has treated those exceptions as having been filed. They've reviewed them significantly. They've reviewed the record. They've determined that the record has competent substantial evidence for every finding of fact that is contained therein. And we would ask you to adopt the staff draft final order as the final order of this commission. Thank you.
Thank you, Mr. Herron. Any questions for Mr. Herron? Thanks. Ms. Weeks, would you like to make any rebuttal comments?
Again, Mr. Herron references the proceeding participation, and I did participate in the DOAH proceeding, but again, like I said, shouldn't have gotten to that because there was not accurate and reliable information for the DOAH judge to make a determination on. And Mr. Herron also indicated that the complaint contained lies against Mr. Hadid. There was no lies that were in there, and that could have been proven had the investigator relied on the actual records rather than what Mr. Herron had to say and hearsay from other individuals, rather than relying on the actual records that existed. And also, as far as the exceptions, I didn't know that I needed to file those with Mr. Herron. I followed the instructions that were on the documentation that I received and made sure that I got that in within with the best that I could within the 15 days. So it was not intentionally omitted everything else that I had filed, including the hundreds of pages of facts of public records, documents, not hearsay, that were faxed to the DOAH, for that hearing, to give her factual information to rely on, because that factual information was not provided to her by the Ethics Commission in their investigation. So that was not an intention on my part to exclude Mr. Herron from those exceptions. But I had participated in everything that I thought that I could participate, and I did make the attempt to participate in the DOAH hearing. I attempted to even appear telephonically and was denied that option as well. So I was not exercised my First Amendment right to be able to participate. Again, like I said, I think that this is a political sham. It gives somebody like Mr. Herron to be able to participate in the investigation. He then can defend a respondent and be able to be heard during a probable cause determination hearing when the complainant cannot. And then he can also then recover fees and costs. And as it's been demonstrated here, he can then go above and beyond what he was initially paid by an insurance provider to be paid to do a job. He can show you that he can get paid twice to do the same job. Thank you.
Members of the commission, I will confess I was a bit snagged by the concern that we could have a policy that allowed or that said everything had to be filed by 5 o'clock or it fell to the next business day, but it's not a policy. It's actually an administrative rule. And what the rule says, if you are concerned about this, like I was, is that any document received by the office of the agency clerk before 5 o'clock p.m. shall be filed as of that day. But any document received after 5 o'clock p.m. shall be filed as of 8 o'clock on the next regular business day. That's what Mr. Anderson said before, but I wasn't sure if it was clear to everyone that it is a rule. It is not just a policy or process that's been adopted by this commission. With that, we still have had the opportunity to meaningfully consider the points raised in those exceptions, and they're set forth in the staff's recommended order, draft final order, I should say. With that, I would entertain a motion.
A motion that we adopt as our final order the draft final order prepared by staff.
Thank you for that well-stated motion. Is there a second? Any discussion?
Yeah, go ahead.
Commissioner Brady.
I share some of Commissioner Cox's concerns as the other non-attorney. But when I think about this, I fairly vividly remember the probable cause hearings on these particular items, and I have been very comfortable with their reports of investigation on a wide range of cases we've heard. And we listened or read all of the documents, and at that time we basically said we don't believe there's any probable cause for moving forward with any of these complaints. And then fairly recently, as I remember it, we had the petition for fees. And as I recall, we had kind of a discussion, because I think some people are not very comfortable with saying to people that you exercised your right to participate, and now for us to be able to go back and get you, have costs to you for doing that is not a particularly good idea. And I think we approved the petitions kind of reluctantly. But when I listened to Mrs. Weeks, she's going back and arguing the probable cause hearings. She's basically saying that you believed Mr. Herron and your investigators didn't do their job, and you really didn't pay attention to those particular proceedings. And as a consequence of that, now I'm in trouble, not because the administrative law judge found that what I did was untruthful and malicious. It's because you guys didn't do your job in the initial probable cause hearings. And really, as incredibly sympathetic I am at the size of these awards, particularly after people been paid. Not a whole lot of people make $180 an hour, have been paid once. I don't feel that there's anything that's being presented that would really say that I didn't get a fair shake in terms of the second set of DOH proceedings, where I had the opportunity, I assume had the opportunity, to basically display that I'm just exercising my right as a citizen of Florida to report behavior that I find offensive and a violation of the ethics code, and not to go back and say, well, gee whiz, nobody did their job in the first place, so it's not fair now to say it's my problem. So I'm going to vote for this because I don't think there's a way to say we don't think you should get that amount of money in terms of the order, because I think that the process got carried through, and at some point we probably need to have another discussion about how we really feel about people getting awards for costs.
Thank you, Commissioner Brady. Before I call on anyone else who might want to speak, just 1 second, Commissioner Berger, I just wanted to share, and I'm sensitive to particularly the non-lawyers' observations about these rates. And I don't know that this is exactly applicable, but it might help to understand that an insurance company typically is going to offer and pay a lawyer a set rate, but sometimes the client will still agree to pay the balance of that lawyer's fee out of the client's own pockets, so that $100 an hour may be paid by the insurance company, but the client who is insured may offer to pay $100 an hour out of his own pocket in order to retain the lawyer that they want at a $200 an hour rate. And so I think that's a little bit perhaps relevant here, but also the statute doesn't really speak to the public official having paid fees from his or her pocket or the county's pocket. Like it or not, and I'm probably going to have to say that again in this meeting today, the purpose of the statute, as determined by the District Court of Appeals from the 5th DCA, is to punish those who file malicious complaints. And when I look at it from that point of view, it makes it more understandable to me what we are really dealing with is that, and not necessarily so much about whether a person should get the fees that they've sought. Any other comments? Commissioner Berger.
Just a comment. Personally feel it's always good to discuss and reevaluate the process and the policies and procedures. But from looking at this from my perspective, a role here is not to relitigate the facts of the case. A role is to look at the findings of facts that have been established at a hearing. And for instance, if you look at page 2 on the proposal, it says the record shows that Weeks did not appear at the DOH hearing. That therefore is the record that we are left with and the conclusions and findings through the hearing. So based upon the conclusions and findings of that hearing, for lack of a shortened version, was it an erroneous decision? So again, when I look at this, our job is not to relitigate these factual issues. It's to make a decision whether or not this ruling is, for lack of a better term, erroneous. And that's why I voted the way I personally voted on this case. But again, the issues about process, and in my opinion, they're always good to discuss. But that's not why I'm voting the way I'm voting.
Thank you, Commissioner Berger. Commissioner Norris.
Just briefly, multiple issues were heard before DOA, and one of those was the standard on recovery of the attorney's fees requiring malicious intent on the part of the parties bringing the complaint in the first place. And so when you do not participate in a deposition to answer questions and to set forth your grounds for bringing the complaint in the first place, it seems to me you open yourself wide open to finding by the administrative law judge that you had malicious intent because you haven't presented any evidence to the contrary in defense of the claim. Then the second matter that came before was the reasonableness of the attorney's fees based on the hourly rate, and the only aspect of that I happen to have any level of discomfort with in this particular case, because the findings were clear that there was a contract and that the county contracted to pay the difference, as has been noted by the chair. The only level of discomfort I have, but it was based upon the evidence presented, was that the reasonable hourly rate for someone of Mr. Herron in this particular case's experience in presenting the case on behalf of the respondents was anywhere from $250 to $450 an hour, and the administrative law judge split the difference at $350, despite the fact that Mr. Herron apparently had a contract rate of $300 an hour. But there are certainly many cases in which it's appropriate, and there's a statute authorizing it to get attorney's fees that are in excess of the amount of the contract. I might have argued that here, but I don't have anything in this record that would enable us to support that $50 per hour margin difference, which perhaps could have occurred and could have been avoided had the respondent in the DOA case, Ms. Weeks, participated in the action and argued it there, as she has here.
Thanks, Commissioner Norris. Any other comments from commissioners? Hearing none, all of those in favor of the motion that we adopt the draft final order as our commission's final order, please indicate by saying aye.
Aye.
Any opposed?
Aye.
The motion is adopted, and the draft final order is adopted as the commission's final order. Thank you again for your participation today. Moving to the next one on our agenda, item 5E is regarding George Hans, matter 15-174. This is also an attorney's fee proceeding that has been heard by the Division of Administrative Hearings. We have before us another recommended order from the administrative law judge recommending that we award fees against the complainant, Dennis McDonald. Is Mr. McDonald or counsel for the other parties? Mr. McDonald, thank you for being here. Mr. Herron?
Mark Herron and Tito Gimbel on behalf of George Hans.
Thank you. As no exceptions were filed, there appears to be no reason to hear argument by either the petitioner, Mr. Harris, or the respondent, Mr. McDonald. However, we still must proceed under the Administrative Procedure Act. This means that we are unable to reject or modify a finding of fact, just like in the other cases, unless we determine that there is no competent substantial evidence to support the finding. And if we reject or modify a conclusion of law, again like the other cases, we must find that our substituted conclusion of law is as reasonable or more reasonable than the administrative law judges. This time I'd ask the Commission to consider a motion.
Move to approve the draft final order as presented.
Second.
Madam Chair.
Yeah.
I believe that Mr. McDonald ought to have the right to be heard.
Is there any objection to Mr. McDonald being heard, even though there were no exceptions filed? Hearing none, Mr. McDonald, you may come forward.
Thank you.
Go ahead, Mr. McDonald, you have 15 minutes, but if you'd like to reserve some time for rebuttal, just
I
let
will.
me know.
Thank you very much. Appreciate you allowing me to speak. Thank you for allowing me to speak for the first time regarding my complaint 15-174 made against George Hans for his personal actions created as a conflict of interest as a Flagler County Canvassing Board member. For the record, my file contains a registered letter to the Ethics Commission making notice that I was denied the opportunity to speak when co-counsel Herron and Hadid were given notice and opportunity to speak at the first hearing date in August of 2016. It's been interesting listening to you here today, and I think I can shortcut a lot of what has gone on. In my particular case, one of the reasons that I'm here today is to tell you the findings of the advocate do not reflect my singular complaint, which is in bold print, item 6 and item number 9 in 15-174. I complained to this commission that George Hans violated Florida Statute 102-141 in bold print and participated in the election process, and it was known that he had actively participated in the re-election of a co-commissioner. And as of this date, that complaint has never been addressed. There is absolutely no commentary at all in the advocate's report about FS 102-141 violation. Nowhere in it at all. I don't understand how this omission can possibly be allowed to stand. But it's missed not only by the advocate, but by the investigation staff. And so what I'm thinking here is I don't know anything about your process. I'm just a citizen. So I'm thinking that maybe the information that is given to the advocate is all that she can look at, and so she's operating with blinders on. So one of the things that's really perplexing in the investigation is there are verbatim minutes that exist in the public record for the meetings that I'm talking about at the canvassing board meeting, word for word, minutes and record. The two findings listed in the advocate's report were supporting information for the Ethics Commission when I referenced collective actions of the BOCC and staff. Requirement number 2 of your complaint states, please use one complaint form for each person you wish to complain against. I made one submission against George Hans. To further inform this commission of the failed process, I bring the decision of the District Court of Appeals, DCA 16, 724, and 725, where Albert Hadid and Nate McLaughlin sued this very commission. The DCA states, and I quote, the central point we address in this consolidated appeal is the language of section 112.317 subsection 7, which requires the complaint to contain false statements that are material to the violation of the Code of Ethics. The same test for false statements would be applied to my statement here, 15-174. Would this commission believe that the canvassing board's vote by our judge and SOE to confirm that Mr. Hans was an active participant in another commissioner's campaign was not a violation of Florida Statute 102.141? Was that publicly recorded vote a lie? But again, all this is moot because it was never addressed by the Ethics Commission. That's what just baffles me on this whole thing. To further inform the commission, the verbatim minutes are rather illuminating on Mr. Hans's part, okay, especially where on page 84, the SOE asks him this very question. Even when you were made aware of it, meaning his active participation, I did not see you address the issue publicly or at a meeting, end of quote. Mr. Hans replied, waiting for you to bring it up, end of quote. There's a whole lot going on here, and I can get into it more and more, but I wish to address one more issue pertaining to the Ethics Commission complaint process. The Commission's handbooks on ethics found online for public information states on page 19, section D, in the last paragraph, the complainant will be liable for costs plus reasonable attorney's fees incurred by the person complained against. For the record, Mr. Hans has not incurred any costs or fees as they've all been paid for by the insurance company that the county has, PGCS, even though the complaint concerned his personal actions, not as a commissioner, his personal actions. He actively participated in another commissioner's campaign. And that's another issue all unto itself. One of the things I have here, if you care to see it, is the memo from the liability claims supervisor at PGCS, March 29, 2017, where he states very simply that his company has taken no steps to pursue recovery of legal fees in the subject matter. Additionally, I have the minutes of the Flagler County Commission's Board of County Commissioners meeting. In February of 2016, Attorney Herron is introduced by co-counsel Hadid to the commission members, where Mr. Herron actively solicits legal actions be taken against the complainants, also known as the citizens and the taxpayers. The clerk of the court's minutes state, this is a quote, County Attorney Hadid introduced Mr. Mark Herron, who has been retained by the county's insurance carrier to represent its interests, noting that Mr. Herron limits his practice to ethics and law. These public statements made by the County Attorney Hadid are in clear contradiction of the memo from the PGS claims supervisor. Again, in May of 2016, County Attorney Hadid and co-counsel with Mr. Herron brings Mr. Herron to the Board of County Commissioners and solicits more legal actions be taken by the Board of County Commissioners. On this occasion, Mr. Herron's statement in the county clerk's minutes, and this is a quote from the minutes, Mr. Herron explained that the current complaints could not be included, stated that the money paid out thus far was paid by the insurance company. Mr. Herron's 516 remarks confirm for the record that no costs were incurred by Mr. Hans. So by your definition in the handbook, okay, you talk about incur. And we all know that incur is something very personal, okay? That's what you do when you incur something. It is a personal matter. Mr. Hans has not incurred any costs. I believe that I have provided ample facts that demonstrate that the staff at the Ethics Commission has failed the mission in the Florida Commission handbook. What is even more perplexing is that the advocate, Mr. Anderson, who successfully argued the DCA case, and the ALJ never applied the case law from the DCA when Hadid and McLaughlin sued your commission. I forwarded a copy of that DCA case to the ALJ. It was never addressed, but then again, quite honestly, this whole matter never should have gotten this far. It should have stopped back at the original hearing when I could have come and said, wait a minute, that's not my complaint. My complaint is just 102.141. I have every interest in defending my First and 14th Amendment rights that have been clearly violated in the process. The process employed by the Ethics Commission is publicly known to be a concern, as it was on the April 2016 agenda for action. But Mr. Herron, who makes a living defending the respondents, convinced the Commission that it would take up too much time for the Ethics Commission. Due process cannot be afforded proper time by the Ethics Commission? Since when does the truth have a time limit? Or is it that this change to allow due process would impede Mr. Herron's business model? The Commission, if this action is taken against me, would be operating contrary to its Ethics and Sunshine Handbook. It would cause me to defend legally, but also cause me to inform the citizens of Florida and other states using my interests as an op-ed writer. I have seen commentaries in local, state, and even USA Today publications since my run for the Senate in 2015 here in Florida. I ask that you terminate this action for fees and costs claimed by Mr. Hans based on two facts. Mr. Hans fails to demonstrate any incurred costs, as required by the Commission's guide on Sunshine, the Sunshine Amendment and Code to Ethics for Public Officers and Employees, and most of all, my singular complaint regarding violation FS 102-141 has never been addressed by this Ethics Commission. This very embarrassing action on the staff's part was not based on competent, substantial evidence. There can be no findings of fact void of a complaint. And I'd just like to close and say a public office is a public trust. Thank you very much.
Thank you, Mr. McDonald. Mr. Herron, would you like to make remarks? Mr. McDonald, I'm sorry, I should have asked, are there any questions for Mr. McDonald before he leaves? I'm sorry, I didn't let you go. Commissioner Carson.
Mr. McDonald, did you participate at the DOA hearing regarding these fees?
I sent a letter to the judge at the very beginning. I tried to from a citizen standpoint, I tried not to get, I'm not a lawyer. I don't know how to get involved in the legal process, so I sent in 2 communications to her. And that, I guess, would be considered my, my participation, with her. I did send her the DCA case, and I did, at the very beginning, outline my position. Originally, when I got something from the ALJ, she asked me, how much of a hearing was I going to need? How many days was I going to need? And I told her I needed about an hour, maybe, okay, and I would make it as simple as possible. And I tried to do that through the whole process because I find that things get lost in all the details, and you don't stay on track on the primary focus, like in this case.
Let me ask you one follow-up, Madam Chair, if I may. Did you attend the hearing, the DOA hearing on this?
I did not. I wasn't, I don't remember any notice being given to me at all on that. So, I did participate. I did respond. I always respond to the court. I have great respect for the court. One of the reasons why I'm doing this here today is this involves the election process. It's not about the individuals. It's about the election process, keeping it pure and straight, because it gets off-sided so often. And so, having gone to all the canvassing board meetings, and the only reason I went is I had somebody call me who was a retired judge from California saying to me, "Hey, Dennis, I just went to the very first canvassing board meeting way back in July in 2014. I can't go this afternoon, but I'm a 28-year retired family court judge from California, and I'm telling you, there's something going on down there. You really need to go down and watch." So I did, and I went to every single one. And the outcome was, with the complaint that I made, which is certainly public record, and it is not a lie. It's a fact.
Commissioner Cox?
Thank you. So I guess it goes to Mr. McDonald's comments, but it's really more of a question for our executive director. So when I read the order to investigate, it does talk about compliance with Sunshine Law. And it specifically says indicate possible violations of 112.313 for N6, but the order does not address his complaint of 102, which he specifically mentions in the complaint.
The commission doesn't have jurisdiction over Chapter 102.
So
We can only look at the complaint and see if there's anything within the commission's statutes that would be implicated by the factual allegations. And so here it was the 112.316 misuse of office, but the commission wouldn't have the ability to rule on a violation of Chapter 102.
Okay, well, I understand that, and I realize that that's what you were going to say, but I guess my question then is why didn't we not, in the order to investigate, address that situation? Because as he stated, he's not a lawyer. He doesn't understand those things. And if we had put that into the order to investigate, could there have been a possibility where he said, well, then I want to withdraw my complaint and address it with the election commission? And if that was the case, would we be here today? No.
Well, we don't necessarily always put in what's not within our jurisdiction if we find something that is within our jurisdiction to investigate. So he made allegations that were within the commission's jurisdiction, and the complainant doesn't get to retract their complaint just on their own decision making. They have to show good cause to do so before the commission. So my experience, just anecdotally, has been that when a person files a complaint, they want us to investigate it if it implicates any of our laws, and the fact that they raise a law that is not within our jurisdiction, they're just happy for us to investigate it if it does raise an implication of a law that it is within our jurisdiction.
Any follow-up, Commissioner Cox?
I mean, I completely understand what Ms. Doss is saying, but in his very first paragraph of his complaint, it lists 102. I mean, he's very specific about it, and I don't know. I've served on a canvassing board, and some of the things that are in the allegation You know, it's a gray area. And I understand it doesn't fall in our purview, but I think maybe we should have addressed that.
Madam Chair?
You have 2 minutes. You can use it for rebuttal, or you can use it to respond to that.
I just wanted to respond to that. The actual complaints that they took action on, okay, I never made them, okay? They're collective. It was information that I provided. It was collective actions. That's what I was saying. It's collective actions, George Hans, with the whole commission and his staff. I can't separate any of that.
And that answer was short enough. That'll leave you 1.5 minutes for rebuttal. Thank you.
Thanks.
Any other questions before Mr. McDonald steps away? You're good. Thank you. Mr. Heron, as you know, you'll have 15 minutes, and if I could ask you to just preliminarily address the concern that's been mentioned several times today, and I think many people understand it, but I'd appreciate the clarification of the point Mr. McDonald raised with respect to a individual incurring fees versus the insurance company incurring fees and or their right to recover fees incurred by their insured.
This case, these series of cases, presents a unique issue that I have never come across in the course of seeking fees. I have been in cases, kind of like I've been in cases where the agency itself paid the fees, and we've sought to recover those fees to repay the agency, in whole or in part. I've been involved in cases where the fees were incurred but not paid at the time we tried the case, and the award of the fees then paid off those cases. These series of cases is really the first series of cases where an insurance company in advance paid the fees, or while they were being billed to a certain point in time, paid the fees. And again, the record is clear that the intent here with respect to partial payment, the payment of these fees, is to repay the insurance company through the county so that the county's claim history will be put back to normal, at least in part, because of the claims that they had to make with respect to these 26 or so complaints that were filed by this group of complainants. So I believe that based on the Couch case, which was the case that you cited in terms of the purpose of this statute, if you remember, in the Couch case, the county attorney defended the county mayor in that proceeding. And the challenge was brought as to whether that was appropriate. And the court said, yes, it is. The fees could be paid by the complainant, Mr. Couch, in order to cover the costs incurred by the county attorney doing that. By extension, I believe it's appropriate here that the fees can be claimed by Mr. Hans and the other respondents in order to repay the county or repay the insurance company for the money that they've paid. So that's my response to that.
If the commission would defer to me asking one follow-up question. If I did not pay my legal fees, but my great Aunt Myrtle agreed to pay the fees for me,
Right.
would not the statute be interpreted to suggest that even though they were not costs out of my pocket, they were one and the same with my great Aunt Myrtle? Is not the insurance company and Aunt Myrtle in the same shoes?
That's the point I was trying to make with respect to the payment in the Couch case. Is that the county paid the salaries of the county attorneys who defended her, but they were entitled to recover fees pursuant to the claim under this statute. So yes. And again, I would think that your great Aunt Myrtle, that you would repay her in the event you got an award. Yes.
She died a long time ago. I'm not going to worry about that. Any follow-up on that before you move forward?
Yeah, just briefly, again, try to remind the commission as to the nature of this proceeding and why we're here. We're here to deal with whether there were allegations in the complaint which were false or made with reckless disregard to their falsity. Mr. McDonald has focused on his his alleged claim that his complaint only intended to deal with 102 point whatever section of the statute that was. Again, your executive directors told you that 102 is not within the jurisdiction of the commission. If you go back and look at the complaint, however, it's a wad of papers. It is a wad of papers that includes many of the same things that were in these other complaints against these public officials. And, you know, to say that, well, I shouldn't have, you know, I shouldn't be responsible for what I've attached to my complaint and included in my complaint. The commission staff, when they review these complaints for legal sufficiency, they're not trying to parse out, they're looking at the whole thing in totality. And if in totality, on page 52, it alleges something that is different than what's on page 1 or 2, they are going to look at page 52 and say, oh, it alleges matters which, if true, would lead one to conclude there's an alleged violation of the code. That's the test for legal sufficiency. With respect to how we got here, if you recall, we filed in all these cases, including this one, a detailed petition for costs and attorney's fees. And in that petition, we set forth the test of materiality that's in brown, but we also set forth the specific statements in the complaint which were alleged to be false, and tried to show in that petition why they were false. Because again, this commission has taken a very jaundiced view of these types of complaints and petitions. And recognize that we want to try to point out with great specificity what statements in the things are false and why they were material to your determination that you were going to investigate this. And then that brings me to the claim of this other case involving McLaughlin and Hadid versus the commission. And in the draft final orders, the commission staff distinguishes those cases. And again, the distinguishing case is that in those initial McLaughlin and Hadid cases, which are not these complaints, but in those additional complaints, those complaints, the allegations in those complaints were determined by this commission staff to be not material to an alleged violation of the code. And that's why you dismissed them at the legal insufficiency status. The court, when they reviewed that, focused on those points, and they even said that notwithstanding of the fact of all the alleged wrongdoing in there, that in those complaints, the main point in sustaining what this staff did and what this commission did was said they weren't material. I think that's all I have to say at this point in time is essentially there were no exceptions filed here. We would ask you to adopt the draft final order of the commission adopting the recommended order of the administrative law judge. Thank you.
Thank you, Mr. Herron. Mr. McDonald, you have about 90 seconds. I'm so sorry. I'm having trouble remembering after the fourth time asking if anybody has questions from...
Excuse me, I did have one more thing to say, and when I saw Mr. McDonald come up here, it reminded me of what I wanted to say. In this case, there was another instance here where Mr. McDonald was noticed for deposition in the DOH proceedings. He came in, he essentially gave his name and said, I refuse to answer any questions because of Ms. Weeks' pending criminal case, and then left the room. And that transcript is in the record before you. So,
any questions for Mr. Herron? Mr. Anderson, would you like to comment before we have a rebuttal from Mr. McDonald?
Yes, Chair Akers, just briefly. I think the motion is to adopt the staff draft final order. In this matter, like the first two of these today, since there were no exceptions filed, either timely or late, you do not have a draft final order before you. The motion really is to accept the recommended order, and if you decide to do that, then what will be rendered will be a very short order adopting the recommended order that will not treat non-existent exceptions.
Understood. And I know I was jumping to get to that motion before we allowed Mr. McDonald to speak, so we're going to start fresh after Mr. McDonald has his rebuttal. So whoever makes the motion, please consider Mr. Anderson's counsel. Now, really.
I would just like to say that it never should have gotten this far. It should, if it wasn't something that was covered, my only complaint, my singular complaint that's in that, It should have been turned away at the get-go, and I should have gone off to the Elections Commission, as was said, if that's how it works. And I just want to say there is absolutely nothing that's a lie, and there's nothing malicious about this at all. Mr. Herron would like to paint the fact that I go after public elected officials. I do not. Okay, my wife is the vice chair of the school board in Flagler County. I take the election process very seriously, and maybe I shouldn't, but I do, and we have to uphold that standard no matter what party it is or anything. And in this particular case, you know, the charges that were brought forward were items that I presented that were collective in nature, and your very own process on your item number 2 says I can only complain about one person. I didn't complain about the commission or the staff or the Board of County Commissioners or whatever in Flagler County. I complained about George Hans, and the only one that relates to George Hans is 102.141. If it didn't apply, then the commission should have turned me away, as they have done on numerous occasions with other people. And if you had a process that would allow people to speak, that would just be the fairest of all. So thank you very much, and I want you to go away, you all knowing that I'm not a malicious guy. So thank you very much.
Thank you, Mr. McDonald. But before you leave, Commissioner Rosenka has a question.
Mr. McDonald, I'm a little concerned that said you weren't invited to participate in the DOA proceeding.
I'm sorry?
You had said, or I heard from the audience, that you weren't invited to participate in the DOA proceeding.
No.
Okay, I see a number of orders and notice of hearings that have your address on them with the post office box. Did you not receive those notice of hearings and continuance orders and?
I'm sorry. As I responded twice to the judge. I thought that that's all that I had to do. Okay? I mean, I don't want to take up a lot of time. It's just not necessary. It's just arguing about details that never get to the point. That's how we get lost in society that we're living in today. We don't focus on, what really counts. And so I had said my piece to whatever I had said to the ALJ. I didn't wish to say anything at the deposition, because in no way did I want to injure or cause any harm to the SOE, because I had been a person that was called because I was at every single canvassing board meeting. Who does the FDLE call? Hey, who's the big guy in the film? Let's talk to him. So I get called in by the FDLE. So and so consequently, I don't know anything about this. I'm a construction guy. I don't know anything about the legal world. And so I just try and stay out of things that I don't know anything about. And so that was my intent. And I don't understand the ALJ process at all. So I thought I had responded by making those, registered letters and sending them to the judge. I honestly can't say, and with my wife's work and a lot of the stuff that we do, she teaches nationally also, and so we're not around a lot. If it's not school board week, then we might be off. I go with her, and she teaches, around the country. That keeps us pretty busy, and it could very well be that if there are registered letters, I know there were some registered that I missed. We just never got back in time to get them. Thank you.
Any other questions for Mr. McDonald? Thank you for your participation and for being willing to make the trip and express your position today. Right. Having heard the argument of parties and counsel, this time I'd entertain a motion.
I'll move that we deny the request for fees. Yes, thank you.
So Commissioner Cox has moved that we reject, I think would be the word that you might choose, the recommended order of the ALJ. Before I hear whether there's a second, Mr. Anderson, I think, has some advice.
Thank you, Chair Anchors. If I'm not remembering incorrectly, I thought there was a motion on the floor by Commissioner Brady to accept the recommended order.
Ask the clerk, because that happened
I think he's correct.
Right before I called up Mr. McDonald, who I did not think we would hear from because there were no exceptions. Was there a motion on the floor? Commissioner Brady's motion was that the recommended order of the administrative law judge be accepted as the order of the commission. Is that correct?
Yes.
And was there a second, Madam Clerk?
I withdraw my motion.
Was there a second, Madam Clerk? Or does anyone here recall whether there was a second to that motion?
There was. I think Commissioner Berger made it, and I withdraw my motion.
Okay. Commissioner Berger, did you second that motion?
I think Commissioner Morris seconded
Do you recall?
Going for a while.
Okay, we're going,
Wasn't me, I can
with the permission of the commission, I'm going to ask Commissioner Brady to restate his motion, which was to accept the recommended order of the administrative law judge as our final order.
it. So moved.
Has that been seconded?
I'll second.
Seconded by Commissioner Berger. Thank you, Commissioner Cox, for withdrawing your motion in honor of the previously made one. Is there any discussion?
Just under discussion, I think if you go right back to the original complaint and the order to investigate, I think we sort of dropped the ball on that, so. And well, that's all I'm gonna say, thanks.
Any other debate?
Well, Madam Chair.
Commissioner Carson?
To the extent what Mr. McDonald presented today was persuasive testimony or explanation of his position regarding his underlying complaint, it really should have been made to DOA. And I'm concerned that we've heard from two different, complainants, underlying complainants, and then respondents in these fee petitions where, notices of hearing are being ignored, or at least they're not, folks aren't using that opportunity to explain these issues. I have some experience at DOA, and my experience at DOA has always been that they are about as friendly a forum for pro se litigants, unrepresented litigants as anywhere in the state. They're designed that way. A lot of the types of cases that DOA judges hear are not, both sides aren't necessarily represented by attorneys. These arguments that we've been hearing, especially with Mr. McDonald, should have been presented to the ALJ and very well may have changed the outcome of the petition hearing. At this point, we're given a recommended order, no exceptions. We've got no evidence that, this is my opinion, we've got no evidence that we can rely on to overcome the ALJ's findings of fact, and it follows that we really have no basis, in my opinion, to overrule the ALJ's conclusions of law. So, Mr. McDonald, thank you for your explanation today, but I believe under the Chapter 120, our hands are tied here, and we have no choice but to accept the ALJ's recommended order.
Any other comments from any other commissioners?
I'd just like to,
Commissioner Cox?
and I completely understand everything that you're saying, and there's no doubt in my mind that legally you're correct, okay? Probably what should have happened a long time ago is that the complainant file a response to the advocate's recommendation, or file a response to the report of investigation. But these are lay people. They don't know to do that. You all know how to do that, except for you, Commissioner Brady. You all know how to do that, but the rest of us don't. And so the effect of all of this is that you're going to stifle the public's voice, because the public is going to say, you know what, I'm not going to take a chance on this because these elected officials have these insurance companies and these staff attorneys that they'll come after me. And so the public's trust is not being represented here. Legally, you're correct. You're 100% correct. So God bless you. But from a standpoint of these lay people, it's just, I don't think it's correct. I'm going to vote against it, obviously. Thanks.
Any other comments from commissioners? Hearing none, all those in favor of the motion to adopt the recommended order as the final order of the commission, please indicate by saying aye.
Aye.
Any opposed?
Aye.
The motion passes and the recommended order is adopted. At this time, I'm going to suggest we take a 12-minute recess and reconvene about 10:35.
Is there significance?
I like to be, right on. Extensive argument during our last meeting with a very thorough and, in my opinion, meaningful discussion about these issues, and after which there was a motion to adopt the draft, and that failed on a tie vote. We have that same draft before us, but today we have a full complement of our members. Mr. Carson was not here for that vote at the last time, but it is my understanding, correct me if I'm wrong, that you had the opportunity to review the meeting video and our discussion of this particular advisory opinion?
Yes, ma'am.
Is that correct? Did you review it twice?
Yeah, at least twice. The really exciting part's a third time.
All right. I don't want to put you on the spot, Commissioner Carson, but I'd also like to make sure we gave you the opportunity, particularly to have any questions that you might have asked. And in addition to Commissioner Carson, of course, all members of this commission are welcome to ask the staff questions or to ask Mr. Gibson questions. We had the opportunity to hear from Mr. Gibson at the last meeting, and as I have said then, I'll say it again, I enjoyed that discussion, although it was probably a little tortured for you to listen to, and thank you for making another trip here. If anybody has any questions for Mr. Gibson or for the staff, please let us know now. If not, hearing none, then I would ask for a motion on this advisory opinion, which is file 2696.
Madam Chair, if I could.
Yes.
Sorry, if I could just have a couple minutes to,
You may.
because I didn't get.
That is the point here.
Thank you, ma'am. To participate in the last one. As always, it's a well-written, well-reasoned, and well-founded opinion from, or draft opinion from our staff. But having the opportunity, again, I showed up, I think, about 3 minutes after the
Maybe
vote was
3
taken.
seconds.
Yeah. And, having reviewed the agenda in advance of the last meeting, this wasn't necessarily the one I thought would take up the majority of the commission's time. I was sorry to miss it. But having a chance to review that, understanding it and seeing that it was going to come up again at this meeting, I did look at it and I did consider, I think, what is the major sticking point. If I could be so bold as to suggest that the main sticking point for the no votes last time was this item number 3, or question number 3, and whether or not a charter school, to overgeneralize or to paint with too broad a brush, is whether or not a charter school is a public agency in general and for purposes of the ethics code. And I too share some concern regarding that for a couple reasons. One, I think that the specific code provision, 112.31433A, that talks about voting of conflict for state, for local elective officers, talks about no local public officer shall vote in his official capacity on any measure which would inure to his or her own private gain or loss, special private gain or loss of a principal, unless that principal is an agency. And my understanding of that provision is so that local elected officials whose principals are agencies are able to vote on matters that may inure to their private gain or loss. And so looking at it under that kind of broad umbrella, it seems to me that a charter school, which and I believe was established fairly conclusively at the last meeting, charter schools in Florida are public schools in operation, in function, and by statute. So it seems to me that what would be good for any other public agency or agency under this statute would also be good for a charter school. The other issue that I have with it is, and I think Mr. Schaefer explained this at the last meeting, was it doesn't change the analysis. In other words, the specific factual scenario presented by Mr. Gibson wouldn't change if the answer to number 3 was different, and it wouldn't change if we didn't answer number 3 at all. In other words, there's other restrictions and other portions of the law that would guide Mr. Gibson's ability to vote on this particular issue. So for that reason, if I could jump right into a motion, I would move that we, the commission, adopt the draft advisory opinion, thank you, for questions 1 or 2, and not answer number 3.
Second.
You've heard the motion, which has been seconded by Commissioner Rosanka. Is there any discussion?
You know, I think it was
Commissioner Brady.
very, very clear when we did this the first time that there was actually no issues with Mr. Gibson, a clear understanding on the part of everyone that what he was doing was an exceptional service to the community, but it doesn't change some of the underlying statutes, and that we appreciate his efforts throughout his long and productive career in Florida, and sorry this just kind of sorts out this way.
Thank you, Commissioner Brady. Any other comments?
Just wanted to clarify.
Commissioner Berger?
What are we doing with question number 3?
You're omitting it. You're omitting both the question could be asked, but there is no response.
Which is really the argument the nay votes had, right? If I remember right.
I believe that that was their position.
Yeah, I was one of them. So, yeah, so were you. Okay. All
Does
right,
that
makes
answer your
sense. That
question,
makes
Mr.
sense,
Berger?
yeah.
With thanks for the work and analysis that went into the response to number 3. Any other comments or questions before we take the vote? All right, just for clarity, to restate the motion that Commissioner Carson made is to adopt the draft advisory opinion for file 2696 with respect to questions and the responses proposed for number 1 and number 2, and to omit the response for question number 3. That's been moved and seconded. All those in favor of the motion, please indicate by saying aye.
Aye.
Any opposed? The motion passes. Thank you again, Mr. and Mrs. Gibson, for being with us and for your participation on many levels in our Florida government.
Where does that leave us? I have no objection to 1 and 2.
Then you're going to get the opinion that explains number 1 and 2 as drafted. That will be the opinion.
As to 3 was the only area where it was felt that I had a conflict.
So you'll be guided by number 1 and number 2, and perhaps leaving you uncertain with respect to number 3. Mr. Schaefer, do you have anything you'd like to add to that? as
Nothing
staff?
further.
Won't be the first time today or the last time before noon that this is a somewhat unsatisfying process at times. But thank you again. The next item on our agenda is consideration of advisory opinion, file number 2704, and I will ask for a presentation by Mr. Anderson.
Let me look at it.
Mr. Anderson, are you up?
Thank you, Chair Anchors. Apologize for the inattention there initially. No. The essence of this matter is a gift and an expenditure case about whether or not the naming of a facility at the Orlando Airport Authority after a sitting public official, state or local level, whether that would be a problem under the expenditure of the gift laws. And under the facts of this opinion, the inquiry states that there would be no cost attributable to the naming. And so therefore, because both the expenditure ban and the gift laws are triggered by things having value, the draft opinion states that this naming would be proper.
and that it would not violate either law. And, it looks like, a traditional sort of thing, but we had to vet it under the technicalities of the statute and under the factual scenario presented. It appears that it's good to go and doesn't look controversial in terms of what's asked or what is drafted, and this would be offered for your consideration for adoption if you choose to do so.
Thank you, Mr. Anderson. Is the requester, Mr. Kruppenbacher, present?
Madam Chair, I would move for approval of the opinion.
It's been moved in, that we approve and seconded by Commissioner Rosenka. Any discussion? Hearing none, all those in favor of the motion to approve the advisory opinion, please indicate by saying aye.
Aye.
Any opposed? The motion passes and the opinion is adopted. Thank you, Mr. Anderson. The next file, 2705, dealing with post-employment restrictions, is going to be presented by Ms. Daly. And before you begin, Ms. Daly, let me just ask if the requester for that opinion is here.
Yes, I am.
Thank you. Mr. Rosinski, is that right? Lupazinski. Thank you for being with us. Ms. Daly.
Thank you. This opinion is being requested by Mr. Lubazinski, who is a former employee of the Florida Department of Environmental Protection. You are getting a handout now. Would you like a little time to look at it?
Could you give us just a minute to make sure we're all settled? Does anybody need any more time? I think we're ready, Ms. Daly. And if I could ask you, as I'm sure you probably already intended to the best of your ability, to respond to some of the issues that were raised in the response that we received just now.
I will do that. The question here, Commissioners, is how the 2-year post-public employment restriction on representation or lobbying applies to the requester's private employment as an environmental engineering consultant representing clients before the department where he was employed. The requester states that he worked in various capacities with DEP during the past 20 years. Before his retirement this past March, he was employed in the department's Central District based in Orlando, where he was a manager responsible for solid waste, air, and environmental resource permitting programs, and also provided opinions to compliance personnel in the Central District. He stated that he also participated in regular monthly teleconferences with personnel in Tallahassee headquarters in the divisions of Waste Management and Air Resource Management and the Environmental Resource Program within the Division of Water Resource Management. During these monthly conferences, he sought and received clarification of policy or technical concerns. Because his position was classified as selected exempt service, he is subject to the 2-year lobbying representation restriction in Section 112.313, subsection 9A4. Under this provision, he is prohibited from representing clients for compensation before his former agency during the 2 years after leaving his DEP position. So the remaining question is, what is considered to be his former agency for purposes of this restriction? And this is also the question that he addressed in his letter to you. Beginning in 2011, the Ethics Commission in CEO 11-10 and subsequent opinions harmonized its interpretation of agency as to 9A4 with its previous interpretation of agency as to 112.313.7a, conflicting employment or contractual relationship. The interpretation is that a former employee's former agency is not necessarily the whole of a department, division, or other unit of a government entity, but rather is the lowest departmental unit within which a public officer or employee's influence might reasonably be considered to extend. Also, in CEO 1110, the Commission stated it's obvious that this 2-year restriction is intended to prohibit a former employee from putting his or her presence, advocacy, and submissions before the government place that he or she formerly inhabited and before the persons who remain there. Then, in CEO 11-24, in determining where a former Department of Children and Families employee had influence, the Commission stated it looked to the parts of the state agency where that employee had a presence. After clarification from Mr. Lubazinski in emails and phone calls about his presence within the departmental units of DEP, we determined that based on these facts that he presented to us, his agency is not for the purpose of 9A4, the entire department with all of its statewide offices. However, in accord with CEO 11-24, we determined that his influence, that is, his presence, extended to all personnel in the Central District and also to personnel in the divisions of Waste Management and Air Resource Management and the Environmental Resource Program within the Division of Water Resource Management. Even though he was not physically present in DEP's Tallahassee headquarters, he described a presence in these specified divisions by virtue of his interactions during regular teleconferences and through his seeking and receiving information, clarification, and direction from division personnel. Therefore, the draft opinion concludes that the named departmental units of DEP, not the entire agency of DEP, constitute his former agency, and thus he is barred for 2 years from representing clients before these governmental units. Also, based on his assurance that he would not be employed or in a contractual relationship in connection with any contract he helped to procure or for which he had responsibility at DEP, the opinion concludes that the other post-employment provision for former state agency employees, that is 112.3185, does not restrict his private employment as long as there's no contractual overlap. So this draft opinion is presented for your consideration. I will be glad to address any questions either now or after the requester addresses you.
Thank you, Ms. Daly. Any questions for Ms. Daly? Mr. Lubizinski, would you like to make any comments?
Good morning. Thank you for allowing me to discuss my case. I agree that Section 112.313(9)(a)(4), which prohibits a former state agency SCS employee from representation contact for a period of 2 years, does apply to me. I agree that my agency includes every program in the Florida Department of Environmental Protection Central District office. The point of contention is whether my agency should be enlarged to include the FDEP divisions of waste management and air resource management and the environmental resource program in the Division of Water Resource Management. So you've had the opportunity to read the letter that I sent in yesterday. And I just want to summarize why the FDEP divisions should not be part of my agency. As was stated, a public employees agency is the lowest departmental unit within which the employee's influence might reasonably be considered to extend. All the opinions that I cited in my letter make clear that there must be influence over someone. CEO 16-14 clarifies that having authority over or any responsibilities regarding any personnel or activities is an important consideration. All the opinions indicate that having interactions with other offices does not mean presence has been established or influence has been established. With regard to limiting representation contact, the opinions did not include in the definition of agency all other offices that the employee had interactions with. And to summarize each of the 4 cases, in CEO 11-24, which is the opinion that is relied upon the most, the DCF employee was allowed to have representation contact with staff at other DCF regions, even though she had work interactions and attendance at meetings with staff from other DCF regions. And that work included transferring cases from one to the other. So it's a close working relationship. It's not just a casual thing. In CEO 11-10, the definition of agency was not enlarged to include those offices with which an FDOT District 7 senior management system employee had interactions but no control or job responsibilities. He was limited only to his former workplace, that is, FDOT District 7. CEO 11-21 did limit the representation contact capabilities of a different FDOT District 7 employee to 2 FDOT districts. However, his job description clearly stated he had responsibilities in both districts. CEO 16-14 clarified that influence is based on responsibility and supervisory relationships, not on attendance at the same meetings or teleconferences. So what I'm requesting, and stated in the letter, is that my agency be defined as the FDEP Central District and all mention of FDEP divisions be removed from the opinion. Thank you.
Thank you. Any questions for the requester? Commissioner Brady?
In the opinion, it speaks about you providing clarification of policy or technical concerns for these subject areas. Can you talk about what that involved?
Oh, yes, sir. The interactions with the division, the way that FDEP is set up, the districts are the regulatory component of the department. And so we take the actions, we issue a lot of the permits. The divisions, although they do some of those same actions, their primary role in regard to the districts is that they set policy and ensure everybody follows that policy. So about 2 years ago or so, I was given the additional responsibility for doing environmental resource permitting. So I wanted to make sure that I was following the policies correctly and I was implementing them in a technically correct manner. So I would call, one example is that a person had a single family lot and they were going to disturb the storm ditch that was in front of them. They wanted to use that to direct their stormwater there. And so, can we just go ahead and give them an exemption, or do we have to make them go through the whole permitting process? So that'd be the type of thing, while I was learning, is calling the division, the experts up there, and asking them about that technical issue. Also during the monthly teleconferences, and these aren't just me and the division, the monthly teleconferences are all the districts talking with the divisions about various topics that are important. Those types of things would come up, and so that's what the discussions would be about.
Go ahead.
So would you consider your role then in the teleconferences and in the technical assistance to be substantial to the extent that the direction you provided served as a way for people to move forward?
Not in the sense that you're saying. So I had a substantial role in the participation because in some cases I was raising the question and giving the background of the case. Now, I had an opinion about how we should go forward with that case. If the people at the division level said, no, that's wrong, then I had to change and do it their way.
Okay. Thank you.
Any other questions for Mr. Lubezetsky? Thank you for being with us. Ms. Daly, did you have any other follow-up comments?
Yes, I would just like to speak a little bit about some of those opinions that he cited. The issue of whether it's authority or responsibility is what influence is not the way that the commission has gone. It has to do with the regularity of presence. And so the reason that we went in this case, and every case is different, and each one of these goes on its own facts. In this case, he told us that he had regular monthly teleconferences where he had the conversations such as he just described to you. And in one of the previous opinions that he cited, which was 1614, it was occasional meetings, and there was much less of a presence reported. And the fact that in that opinion there was a reference to supervisory responsibility was a secondary factor. It was not the factor. In opinion 11-24, which we did really look to substantially for this opinion, that particular requester did not have a particular supervisory responsibility. She was, her title was consultant, and so that was not a factor there. It was presence or lack of presence. So that's the way we've been interpreting in these opinions, what is somebody's agency when we're trying to really help them to narrow down the agency from the whole agency, which is what it used to be. So that's how that determination was made.
Thank you, Ms. Daly. Any questions of Ms. Daly? Ms. Daly, I have just a phrasing question about the phrase representation contact. Where did that come from? It's just awkward language to me.
It's defined in, and it is, every time we have one of these opinions, we have a footnote that, you know, refers to it, and it just is kind of come through all these opinions. And it refers to the fact that you really cannot have any real contact with your former agency.
It's more just the awkwardness of the phrase to me, not anything different, and we have to continue, well, we continue using it, whether we have to or not, for another day. Any other questions? If not, I would entertain a motion regarding this opinion. It's been moved to approve the draft opinion. Is there a second?
Second.
It's been seconded by Commissioner Berger. Commissioner Carson.
I'm sorry, did you say?
I think she meant 7:05.
Oh, I'm sorry. Yeah, 2705, sorry.
Any other discussion? Hearing none. All those in favor of the motion to adopt the proposed opinion in file 2705, please indicate by saying aye.
Aye.
Any opposed?
No.
Nay. The motion passes and the draft opinion is adopted. The next item on our agenda is file 2706, and that will be presented by Ms. Clanky. Is the requester for that opinion here? Thank you. But we do have a handout. Ms. Plinky, I think we're probably about there. You may proceed.
Excellent. File number 2706 arose from a question posed by an attorney for the Miami-Dade Value Adjustment Board. Value adjustment boards, as you may be aware, are created in each county of the state to analyze property tax-related issues. And in pertinent part, in section 194.015, it further provides that each value adjustment board shall appoint a private attorney to provide regular legal counsel to the board pursuant to contract. The requester in the instant case has been selected by the Miami-Dade Value Adjustment Board as their sole legal counsel and provides their board with advice on an array of matters, including employment issues, contractual issues, and ensuring that the Miami-Dade Value Adjustment Board adheres to all provisions of Florida law. In question 1, he inquires whether there is any provision of the Code of Ethics that would prohibit him personally from representing himself in his private capacity before the Value Adjustment Board which he serves regarding solely the value or assessed property value of his own home or property. In addition, he further inquires whether or not there is any provision of the Code of Ethics that would prohibit him from representing property-owning entities or corporations that he owns or has substantial control over before his own Miami-Dade Value Adjustment Board. Germane to this analysis is section 112.313, subsection 16 of the Code of Ethics. It's applicable solely to local government attorneys. The term local government attorney is defined to mean any individual who routinely serves as an attorney for a unit of local government. And unit of local government includes, but is not limited to, municipalities, counties, and special districts. The first part of the opinion provides that as the requester is the sole attorney retained by the Miami-Dade Value Adjustment Board to provide it with guidance and counsel, and he acknowledges that he regularly does so on an array of legal issues, and the respective value adjustment boards are created to serve the counties in which they exist and are populated and staffed thereby, they constitute a unit of local government, and therefore this provision of the Code of Ethics applies to him. Most relevant to this analysis is section 112.313(16)(c), which provides that no local government attorney or their law firm in which the local government attorney is a member, partner, or employee shall represent a private individual or entity before the unit of local government which the local government attorney provides legal services to. In light of this provision, question 1 of the opinion recommends that section 112.313 subsection 16(c) would not prohibit a value adjustment board attorney, such as the requester, from representing solely himself in the challenge of an assessed property value of his own home or property, even before the value adjustment board that he is contractually obligated to serve. However, the opinion goes on to say that the statute would prohibit him from representing any other person or entity in a proceeding before the Miami-Dade Value Adjustment Board, and this includes corporations over which he has ownership or control. Incidentally, I note that this analysis comports also with the statutory language of section 194.015, which creates the Value Adjustment Board attorney position, which the requester currently holds, and provides that the Value Adjustment Board attorneys are prohibited from representing, quote, any property owner in any administrative or judicial review of property taxes. As to the requester's comments, I have spoken with him extensively regarding his thoughts on the draft opinion. And although he has expressed his support generally for the opinion, he would like the conclusions reflected on respective pages 4, 5, and 6 to be changed so as to provide that value adjustment board attorneys may represent not only themselves personally before their own board, but also represent any corporation, limited liability company, or trust over which they have an ownership or control interest before their own board. For obvious reasons, furthermore, he cites as a basis for this assertion and request provisions of the United States Constitution, the U.S. Civil Rights Act, and the Florida Taxpayer Bill of Rights. And he further provides that he is also, as an attorney, regulated by the Florida Bar, and therefore the application of this Code of Ethics provision is not necessary in the instant case. Staff contends that the draft opinion before you applies the unambiguous language of Section 112.313.16c. It, for the reasons I've expressed, expressly prohibits local government attorneys from representing individuals other than themselves before the boards that they provide legal counsel to. Even in light of this provision, we have acknowledged and honored the requester's constitutional right to represent himself as a private citizen before his own board. However, we believe that should we acquiesce to his additional language to allowing him and other VAB board attorneys to represent other corporations, it would constitute the representation of entities before his own board, and therefore we could obviously see could give rise to instances of abuse. Thus, we do not believe that the addition of the requester's language would be appropriate, nor would it comport with the statutory requirements of the Code of Ethics. In addition, question 2, the requester inquires whether there's any provision of the Code of Ethics that would prohibit a value adjustment board attorney from participating in an email listserv that is limited to value adjustment board attorneys and used for the conveyance of ideas with respect to representation thereof. For the reasons set forth in the opinion, there is no provision of the Code of Ethics that would prohibit this activity, and we submit our recommendation accordingly. This draft opinion is submitted for your review, and I'm available to answer any questions you might have.
Thank you. Are there any questions for Ms. Klinke? Commissioner Carson.
Thank you, Madam Chair. You addressed my one concern, which is if any value adjustment board attorney who has a small partial ownership in a larger corporation would then be representing necessarily people other than himself before the board he represents. Is there a difference if, for example, the value adjustment board attorney is the sole owner of the corporation that owns the property?
We don't, legally speaking, there is no difference. As an incorporated entity has a separate personhood from that of which the individual private citizen has by design. It affords them with certain rights and abilities, but it also separates the identity of the corporation or incorporated entity from that of the citizen. And so, and therefore, representation of that entity personally by this particular individual, we believe would be prohibited by the language of the statute.
It's no longer representing himself.
Correct.
Okay, thank you.
Any other questions?
There's a comment. A lot of my clients will buy properties and they form LLCs to protect themselves because normally they're renting them out and all that, so they're protecting themselves and shielding their assets, but they control everything. And I had difficulty with the corporation issue, which is one of the reasons why we've asked for that to be addressed by the legislature, which they won't. But could there be a provision made where the corporation is strictly owned by only one person?
Those facts would have to be before us for our consideration. In the instant case, we asked the requester, given his initial comments, to provide us with facts regarding the ownership interest in the LLC or trust or corporation of which he was theorizing about, and he declined to provide those facts.
Okay.
But if those facts were before us, it's possible that we could have the interpretation you suggest, and I probably agree with Commissioner Norris.
Not all business entities, I think, are treated exactly the same under the tax code. Now, I'm not a tax attorney, but I certainly know that limited liability companies, as an example, if they're owned 100% by a single individual or by a husband and wife, the IRS at least considers those to be a disregarded entity and it's same as their personal ownership. Now, that's clearly for tax purposes, but it seems to me to be analogous here as to the individual ownership if it's 100%, and there's other provisions in the state laws and regulations with regard to that those kind of points, such as like with documentary stamp taxes. If I own a limited liability company and I own it 100%, and I transfer property from myself to the limited liability company, that's not considered a taxable transaction under the documentary stamp tax law because of the identity of the ownership. And that's true even if I'm not the only owner, and there are multiple owners, but the personal ownership and the transfer to the entities are the same. They're not. That's not taxed as a transaction. And then I also know from some public work and acquiring real estate that in acquiring real estate there's a disclosure so that the school board, for example, when the school board is acquiring real estate, and if it's acquiring real estate from an entity, not an individual, the entity has to disclose the interests of the ownership of the entity, and if anyone is an owner of more than 5%, which is similar concept to what we have in a number of our disclosure requirements with the ethics code. If it's more than 5%, then you're required to disclose that ownership interest. Did you happen? Is that required in the VAB process? I'm not aware of whether or not, if XYZ Corporation is before the VAB, if they have a disclosure requirement for the purposes of the VAB board, making, the whole purpose of that is to establish that there's no individual interest by someone on the VAB board with a conflict over that ownership by making that disclosure. Is there a process like that in the VAB?
Perhaps for the board members themselves, but the unique position of the VAB attorney, which is created by the statute that creates the board, would not have a similar disclosure necessity, I would imagine, attaching, because they are by design in private practice, having practiced for in excess of 5 years, and they are retained pursuant to contract.
Well, let me ask this. If this gentleman was not a lawyer, if he was just an individual, would he be able to represent his own entity before the VAB personally? Or would he be committing the unlicensed practice of law?
Would he, and he would have no position on the board or associated with the VAB?
Well, assuming he's a member of the VAB, and so his corporation would have to disclose that interest, step down, obviously recuse himself from the process. Would he be able to represent himself for his wholly owned corporation?
We have had opinions, which are cited in this opinion, which recognize the ability of individuals serving in a public capacity to represent themselves as inviolable. And that continues to be the case under the context of conflicts of interest.
Yeah, but even when their ownership is through an entity, that's my question. Forget that I'm a lawyer. If I was not a lawyer, I happen to be on the board, but I own this corporation. Am I able to represent my corporation as a layperson, but corporate owner before the VAB, having recused myself from the process?
As a board member adhering to the voting conflict statute, as a board individual seated on the board, could you represent yourself in your own individual capacity, but not solely as that, but rather a separate individual entity before your board? Would you have a material interest?
I think so, but I'm an individual, I'm on a board, but I've got a corporation, it's got a VAB issue. Okay? So I've recused myself from the proceeding of my own case. But now I'm presenting my case. My question to you, I'm a lay person, happen to be a VAB member, I own a corporation, it's got an issue before the VAB. Am I able to represent myself, the entity, I own it 100%, am I able to represent myself, or do I have to go get another lawyer? Or a lawyer?
I got a nod that maybe Mr. Anderson might have a response.
Thank you, Chair Akers. The commission has had both complaints and advisory opinions speaking to the issue of a private corporation of which one is a member, and that corporation has an issue in front of their public board. And the voting conflict statute is part of that analysis, but it's not the whole thing. And the commission has said, and one of these cases is currently on appeal to the DCA, that if you have a matter that is a matter of your public board, that compliance with the voting conflict law is not sufficient, that you have a 112.313.7a status type offense, conflicting employment or contractual relationship, which is sort of analogous to the language in 16C, which was invented to bring in independent contractor, local government attorneys within the ambit of some of the ethics code. But the short answer, from analogy to prior opinions that are very close to this sort of dynamic, would be that if it's your company that you're working for and its own development, or if your company is like representing a client and it's the client's development or matter in front of the board on which you sit, that is prohibited, because you have a private interest in the matter, and that's the short answer. I believe that's what's yielded from the prior decisions of the commission, similar to this.
Okay, so if I'm a lay person, I'm on the VAB, I own a corporation, I own it entirely. I haven't given up my right to challenge the tax assessment based on the fact that I happen to sit on the VAB, not waive that, so I have the ability to bring a case to the VAB. And you're saying I would not, as a lay person, not be able to represent myself, my corporation, my wholly owned entity before the VAB, consistent with this proposed opinion, that this guy as a lawyer can't do that.
I don't think the fact that he's an attorney is the crux of the matter. The crux
Well,
is that
it is to me, Mr. Anderson, in this regard. If our position is that a lay person could represent the corporation before the VAB, but a lawyer could not, then we are discriminating against this gentleman because he's a lawyer. And that's my question.
I don't think our position would be that the layperson would have an out and the lawyer would not, because the decisions I'm thinking about, the people were not lawyers.
Okay.
In the analogous statute.
And so it would be consistent that all of them would be disqualified to represent themselves.
Well, not themselves personally as a natural person, but as their corporate entity.
As the corporate, I have misstated that, as that corporate wholly owned owner.
Right. I don't see there being any difference here with the corporate ownership, whether the corporate owner is a lawyer or a non-lawyer.
Okay.
That would be my view.
Thanks.
Thank you, Commissioner Norris. Thank you, Ms. Klinke and Mr. Anderson. Any other questions or comments?
Move to adopt the advisory opinion as presented.
Do I hear a second? It's been moved and seconded by Commissioner Rosanka to adopt the proposed opinion. Any other discussion? All those in favor of the motion, please indicate by saying aye.
Aye.
Any opposed? The motion passes. We'll move now to item 7, consideration of financial disclosure appeals. These are appeals of automatic fines under the financial disclosure law. There are no cases in which an appellant has requested a hearing. Would any member like to take up any particular appeal separately?
Move for approval en masse.
Second.
It's been moved and seconded that we approve the staff recommendations en masse. And I'm going to just put, you did say recommend that they all be adopted en masse,
Yes,
correct?
yes, ma'am.
Any discussion? All those in favor, please indicate by saying aye.
Aye.
Any opposed? The motion passes. Moving on to item 8. These involves people with disclosure statements which were filed late or not filed at all, and who did not appeal the assessed fine or pay the fine. These cases are before you for the adoption of final orders imposing the fines. Are there any questions, or do I hear a motion?
Or what's the motion?
gotta pick
Motion
one.
is to adopt the listing as presented?
Right,
I mean, what's the-
the recommended final orders as presented.
Move to adopt the recommended final orders as presented.
Is there a second? Any discussion? All those in favor, please indicate by saying aye.
Aye.
Any opposed? The motion passes.
Just so I remember, with these, we basically turn these over to the collection?
Yes.
Okay.
Item 9 on the agenda is a little different than our normal consideration of agenda items. This is a request from the Constitution Revision Commission regarding some of their proposals that would modify Article 2, Section 8. I'm going to defer to our executive director, who's had some contact with the CRC, and ask you to give us an update.
Commissioners, as I said in my memo, they asked me to come over there and talk to their Ethics and Elections Committee about the post office holding restrictions that are in Article 2, Section 8. I did that, and in the course of that discussion, they said, well, you know, we've got some proposals here and some more coming out. Maybe you could take them before your commission and see if they have any comment or whatever. There are 4 proposals here. Plus, I didn't realize this, but there's also a 5th one floating out there that's just a shell. It says the Constitution Revision Commission intends to revise provisions in Article 2, which relate to ethics and elections. That's not something that I included. That's just a shell in case they come up with any other ideas in the future. I've really given a lot of thought to this, and to any advice or considerations I might share with you. In this case, it's extremely flattering and really a great honor that they would be interested in the commission's opinion. Having said that, the issues addressed in these 4 proposals are unlike our legislative proposals, where we address issues that you see on a daily basis that are kind of down in the nitty-gritty. These are really high-level, 30,000 feet, pure policy questions. And to the extent I have any advice at all, I would just remind you that there's no requirement that you vote that you like one better than the other, or that you vote at all or comment at all on these. I think that the Constitution Revision Commission has a process that's really pretty competent to be able to handle this. And with that, I will just offer it to you for any comment you might have.
Thank you, Ms. Doss. Does any commissioner have anything they would like to offer on this invitation, or would you like to ask Ms. Doss to thank the CRC for inviting us to participate? And of course, all commission members are allowed in their individual capacities to participate and offer feedback to the commission. But if collectively we don't want to have a discussion of policy for the constitutional provisions that might be before them, then we can ask Ms. Doss to convey that respectfully, and still leave open the opportunity for anyone to participate as they might choose individually. Hearing no discussion, that's my suggestion. Commissioner Carson.
I agree with what you just said. No, if that was your position, I echo it, and the position, I believe, what I heard from our executive director. And you know, the CRC's done a great job of trying to seek input from as many different sources as they can, the public, any interested group, and I suspect they got the executive director of the commission in front of them and said, ooh, tell us what you guys think of these things. And but I agree with our executive director, looking at them, they are more overarching policy issues. A 2-year post-employment restriction versus a 6-year post-employment restriction versus a lifetime post-employment restriction. Those aren't anything that we would necessarily have, respectfully. Maybe I'll just speak for myself. I don't know that my time here I've gained any sort of special insight that would make my opinion of that issue any more valuable than anyone else's. The stuff we generally talk to the legislature about, by contrast, are things where we say, this would help us with this issue, or this would help us achieve what we perceive to be a statutory goal, a legislative intent that's not quite being met with the actual letter of the law where the rubber meets the road. That is where we have a perhaps something special to offer. So I would, I guess, move that we instruct our executive director to politely thank the CRC for its request for input, but decline to provide anything further. And then I'm sure, like everyone else, I've read this stuff and given it great thought before coming to this conclusion.
Is there any discussion on the motion, which has been made by Commissioner Carson and seconded by Commissioner Cox? Commissioner Rosinka.
I just have a question. I thought there was more in here when I was reading this on my desk. Wasn't there an EPC issue that's not here anymore, or is that something else? Requiring financial disclosures of EPC board members?
That's not in any of the constitutional provisions. It might have been in a legislative update.
Any other discussion on that motion? Commissioner Norris.
I just want to say that to the extent that that motion implies that our executive director would ever impolitely make such a comment, I'm going to oppose it, but I'll oppose it on the whole.
And sometime I may.
Too impolitely?
And just for the details on that, what I anticipate would happen is that Ms. Doss would prepare a letter, I would review it, and she would sign off on it. Any other discussion? All those in favor of the motion, please indicate by saying aye. Aye. Any opposed? The motion carries. I do not have any comments for the chair, so I'd ask Ms. Doss if you'd like to just move into the rest of your report.
I will just jump into the legislative report. There's not a whole lot more than what you have in your writing. They're in committee week now, then there won't be anything else until session starts on, I think, January 9th. There is a little bit more. With respect to House Bill 7003, this is the one that would require the commission to institute a local government lobbyist registration procedure. As I was looking at it, because I've been asked to do an agency bill analysis for the House, and so I was looking at it more closely, and there's an issue with the definition of lobbyist in the gift law. For local government officials, they essentially changed the definition of lobbyist, and they specify who is and who is not a lobbyist. Under the language of the bill, for example, a person seeking a permit would not be a lobbyist, or a person seeking a contract less than $20,000 would not be a lobbyist. That's all well and good for a registration process, but under current gift law, those people would meet the definition of lobbyist. So the effect, I'm concerned, of this bill is that now local government officials would be able to get gifts worth more than $100 from a lot more people than they can under current law. So I called staff yesterday to talk to them about that, and they're going to review that. The only other thing, there are a few bills popping up here and there, and I expect a few more will, because the filing deadline, if it's passed, it's only just passed, and things are still coming out of bill drafting. There's a bill in the House, which the bad news is this bill would require local government officials to, report their travel expenses to the Commission on Ethics, stating the purpose of the travel, justifying the necessity of the travel, and providing proof of incurred travel expenses. From an administrative standpoint, I'd really rather not get into the position of maintaining public records for 467 municipalities, 67 counties, etc. But we'll see where that goes. But the good news about that bill is that it says, beginning January 1, 2019, a county or municipal public officer must comply with the applicable financial disclosure requirements of Article 2, Section 8, which would mean Form 6 for municipal officials. So that part of it is very good. I had a very, very nice meeting with Senate President Designate, I can't say that 3 times, Senate President Designate Galvano earlier this week, and he could not have been more gracious. Gave me lots of time. Thought all our proposals were very common sense and represented that he would bring them up at the next leadership meeting. So I'm cautiously optimistic about things on the Senate side. And that, I think, is about it. I will get in contact with Commissioners Carson and Cox to schedule the next legislative committee meeting.
And Commissioner Rosenka, I think that the EDC bill is House Bill 3 that you were thinking of. Any questions for Ms. Dawson on the legislative report? Any other business by any commissioners to come before us in the public session? Hearing none, for those of you who are here for the executive session, understand that we pretty much clear the room except for the agenda item that is before us. So we don't mean to be rude, but it does protect the privacy of all the parties. We stand adjourned until 5 till noon. Not noon, 5 till noon. We can do it. Thank you.